Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020? 7:44 p.m. How does the FBI find people? The people's misspelled P-E-O-O-P-O-N. Did the defendant find out how the FBI finds people in this case? Or she found out?
I apologize. That was a little bit of a wild ride, but we're here now. Welcome to the Court of Public Opinion. I am the recovery addict. We're talking about things that are not relevant. No, we're talking about the Young Thug case. Now we have a document dump that just landed in our laps with a thud. I think I hurt my back. It's heavy. It's reams of paper. We've got 233 pages of a filing to get into. Before we do that, I have to apologize. Because I broke the portal. I told you guys to buckle in, to sit tight, to wait patiently.
Shame on you, sir.
And then the ride never started. I did everything except for engage the portal. And then I closed it out and it was too late. I could do nothing but say sorry. And so here's my apology. Sorry, I broke the portal. You're here now. Welcome. It's also good to have Greeners who's here with us. Greeners first in chat. That just means that Greeners...
I saw a chicken fight.
Yeah. Greeners is going to be in charge of the internet all day. If you have any problems with anything internet related, say your phone, you got a new laptop, needs to connect to your Wi-Fi, your fridge, Wi-Fi is not working. Maybe your thermostat is just a little on the blitz.
The zombie
Greeners can
apocalypse
help.
may be upon us.
So I'm going to be posting Greeners' personal number here in chat in just a moment. Anyone has any? Just kidding. Greeners, I would not do that. I would not do that to you.
When are we going to break for lunch, Judge?
Yeah, it's going to be a short stream. 233 pages. We're not going to read every word of it, but we have a document dump that is spicy. It goes through some of the dirt that leads up to...
Somebody just sent me a video of roaches fighting.
You guys are having fun with the commands this morning. Let's see. Let me make sure I've got the right document pulled up. This is... Oh, that's only 12 pages. That's the wrong one. Oh, there we go.
This is not Burger King. People do not get to have it their way.
They don't get to have it their way.
Because he's the guy.
We want this on continuous scroll. This was filed, shows 8:30 p.m. last night. And I think it was from, let's see, I need to give credit to where this was sourced from. I think Amber found this through a Twitter account named Thugger Daily. Thugger Daily, thank you for breaking this news on Twitter. Appreciate that. Amber's now got the full document for me. Okay, and she's telling a story about a sports announcer. I'll read that story later. That's an odd chat. Those things happen. All right. Without further ado, we're gonna start reading here as people are still wondering why the ride didn't start and they're just filing in one at a time. I'm sorry about that. That was my bad. I apologize. The portal broke, and it was. No, the portal works just fine. It was the operator of the portal that was broken. That was me. I'll own up and take the blame for that one. Let's see. Almost a year of wild rides. Woohoo, says Tammy from Kansas. Thank you very much. 11 months, Tammy. Love it. Unholy Saint, a member for 14 months, says best place to be. You are not wrong. You are not wrong, Unholy Saint. Appreciate that. Let's go ahead and begin this chat.
This is not Burger King. People do not get to have it their way.
Right. Judge Boyd chimes in right there. I don't get to read chat very well while I'm reading this document. So I would ask that we probably keep the sound effects to a minimum during the document reading so we can hear the document. And then if something major happens, then I'll have the sound up so the mods can use the buffer command, which sounds like internet's connecting, like AOL connection. get my attention if I miss something important. I will go back. Obviously, I want to get all of your membership messages and things like that. So we'll go back and address all of those. Other Braxton snuck in just before the limit. It says, member for 5, but been here since the middle of Maya. Thank you. And chat for everything, Braxton. You're one of the good ones. Thank you. Oh, thank you, DMB, for this. Hey. I will forget if I don't tell her right now. She can't hear me. I said it. Hang on. Okay, I've told her. That's exactly. I said, Jen, call your dad. And so, all right. Let's see. Lauren also says, I missed y'all. Member for 6 months. Love the yellow courthouse. Hey, bud. Grandpa. Her dad. All right. We are, Lauren, it's good to have you back. We have a reading, a big reading that's, we were supposed to portal. The portal was my fault. I apologize. Maybe I should pin the message. I broke the portal. I'm like, Jen. That's how no, I didn't. All right, stop calling Mrs. R.A. by her first name. My wife's name is Jen, which is funny when I forget a witness's name and their name is Jen. It's not that I'm forgetting my wife's name. I'm forgetting some other woman's name. That's what I like to remind my wife about. All right. Let's see. All right. Let's begin. We have a massive document to read, and it looks like this. This is how it starts. Let me show you the. This is going to be a rough one. Let me show you the wheel as we scroll down. See the little slider up here in the top right hand corner? Do you guys see that? It barely moves. I mean, we've got a lot of. Let's see, where's that slider gone? Right there. Let's grab it. We've got a lot of pages. We don't have to read everything, but whew. You see that the numbers on the end, it ends with 29. That's because we have multiple documents like attached together. We have emails on here. We have, exhibits. We've got all sorts of case law, loads of exhibits. We've got transcripts. So here we go. Where else are you going to get this read to you but right here? And I'll try to hydrate. I'll remember to hydrate. Do not skip the footnotes. Okay, so you give me 233 pages and you're like, read the fine print too. We want everything. Amber, thank you. I think I'm rethinking your mod status. Is there a way to demote mods? I'm just asking. No, just kidding. Amber's amazing. Okay, wet the whistle. We're ready to go. All right, here we go. This is the Young Thug case. This is a supplemental filing, supplement to motion. It's a supplement to the motion to recuse Judge Glanville, who's the judge over the Young Thug trial. That is the RICO case that is currently on hold because of this motion to recuse the judge. This is going to be considered by other judges. So it comes now, Mr. Jeffrey Williams, that's the defendant, by and through undersigned counsel, that's his lawyers, and hereby timely files this supplement that you have to time. There's a timely requirement. You have to file this within a certain number of days. So timely files this supplement to motion to recuse Judge Glanville, that's the original document, in the above referenced case. That's the state of Georgia versus Jeffrey Williams. In support of this motion, Mr. Williams shows as follows. 1. This supplement to motion to recuse Judge Glanville, as well as the attached joint affidavit, Exhibit A, is timely filed as Uniform Superior Court Rule 25.1 mandates that the time for filing a motion to recuse shall not be later than 5 days after the affiant first learned of the grounds. So they're within the right time frame. This motion applies to lawyers Love and Hilton in addition to Judge Glanville, as all three are material witnesses in the case at bar and will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. Mr. Williams is calling the judge, lawyers Love and Hilton, those are the prosecutors, so they brought them in as witnesses in the case to show judicial and prosecutorial misconduct. This motion also timely moves to recuse the Honorable Judge Krause, this is a second judge, based on the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April, Judge Glanville contributed $2,000 to the Honorable Judge Krause's reelection campaign. Also in April 2024, the Honorable Judge Krause donated $500 to Judge Glanville's reelection campaign. It's money back and forth. They scratch each other's backs. Mr. Williams' trial has been ongoing since January 4th of 2023 and therefore includes April 2024. So those transactions occurred during the trial. So they have given each other money to support each other, at least their election campaigns during the trial. That's the reason for requesting that she gets dismissed, or Judge Krause. I don't know if it's a he or she. Undersigned counsel derives no happiness from filing the supplemental motion. However, let justice be done, though the heavens fall. Actually, the heavens will not fall by unmasking biased and unethical members at the bar. For disqualifications, let's see. So this is all. That was all the small print here. So they say 5 days after the affiant first learns of the grounds for disqualifications. See Exhibit A. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed if it is filed within 5 days after the affiant first learned of the alleged grounds for disqualification, excluding Sundays and Saturdays and Sundays. There's the case law. Thus, this supplement to motion to recuse is timely filed as the additional reasons for this recusal were first learned on Monday, July 1st. When Judge Glanville permitted the court reporter to release the undersigned counsel the transcript of the Monday, June 10th ex parte meeting between Judge Glanville, lawyers Hilton and Love, the Honorable Attorneys Bumpus and her client, sworn witness Mr. Kenneth Copeland, and others. Exhibits attached. This timely filed motion to recuse has also been timely presented to the Honorable Judge Krause and Judge Glanville on Monday, July 8th. In the case at bar, Judge Glanville's ex parte communications with a sworn witness. When they say case at bar, they're talking the underlying case because they've got two cases now, right? They have the case against the defendant, the young thug guy, and then they also have this other case, this motion to dismiss, which is sort of being treated as a case in itself. So in the second one, the motion to dismiss, that's where they're asking to call the judge and the lawyers as witness, not in the main case. I don't know, maybe they'll try that as well. In the case at bar, Judge Glanville's ex parte communications with a sworn witness, his counsel, lawyers Love and Hilton, and other representatives with the Fulton County District Attorney's Office are seemingly only partially captured by the court reporter. They're missing something. Attached here to transcript of the June 10th ex parte hearing. They're saying that the transcript is not complete. Judge Glanville, lawyer Love, and lawyer Hilton have prejudiced and tainted Mr. Williams' trial so deeply as Judge Glanville has not acted as a judge, but morphed into an essential part of the prosecution team. The judge's conduct, this is in the case law, where the judge's contact, including ex parte communication with the prosecutor during trial, resulted in the appearance of bias, requiring reversal of the convictions and sentences. USCR 4.1 mandates that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. They're not supposed to meet without everybody there. Yet, Judge Glanville participated in these ex parte communications. Ex parte means, think of, you cross off one member of the party. You put an X on the member of the party. In this case, they put an X on the defendant, and then they still held the meeting. Once trial starts, everyone should be in on everything. Decisions are made. The judge explains what's happening. There are very few exceptions there. But ex parte, where you cross off one of the members and just don't tell them about the meeting, don't invite them, and do things anyway, not good. But Judge Glanville participated in these ex parte communications and then somehow attempted to keep the secret by referring to the meetings as privileged. Oh, my goodness. Caleb Bumpus did a YouTube live where attorney Melnick and Kenneth Woody Copeland. Oh my goodness. Okay, so he kept them as privileged and describing the improper secrecy as sacrosanct. Sacrosanct. Nobody should know what happens in my chambers. He's thinking it's like Vegas. What happens in Vegas stays in Vegas. It's not the same for the judge's chambers. Judge Glanville has totally abandoned his role as a judge and has become a prosecutor against Mr. Williams. Ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves that the error was harmless. They have case law. So what this means, a presumption of harm, means that the defendant doesn't have to prove that the ex parte communication was bad, that it did something wrong. He can just say the fact that you did it is evidence enough, and we've got case law to back it up. Mr. Williams timely raised his objections to these ex parte communications and recusal of Judge Glanville. He didn't object to the recusal. He raised the objections, and he raised the recusal of Judge Glanville. To wit, when he first learned the same. Attached here, too, in Exhibit C. And we've got the trial transcript, pages 4 through 77, specifically 4 through 9. Attached here, too, motion to recuse. Okay, sacrosanct. Thank you for the Sarah Boone definition here. Sacrosanct means most sacred or holy, inviolable, immune from criticism. And here's the link to Webster Dictionary. As shown herein, the ex parte communications were illegal, immoral, and unethical, diametrically opposed to sacrosanct. What the lawyer's saying here is, you keep using that word. I don't think it means what you think it does to the judge. Sacrosanct is not the definition of that meaning. Canon 2, Rule 2.9 of Georgia Code of Judicial Conduct and former Selection B7 of Canon 3 forbids a judge from considering ex parte communications as judges shall accord to every person who has the legal interest in a proceeding, or that person's lawyer, the right to be heard according to law. Judge Glanville embraced his view that the communications at this ex parte hearing were privileged. Is Adam going to change his name to sacrosanct? Chat is hilarious. I keep catching glimpses of it. Let's see. We've got the entire record of the case in Exhibit B, Exhibit C, and Exhibit E attached here too. Order of contempt and incarceration for Brian Steele filed on June 10th. That's going to be Exhibit E. We'll look into that as well. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of parties or their lawyers concerning a pending or impending proceeding, except communications for administrative purposes, emergencies, consultations with experts, or court personnel and settlement conferences. This literally is why the judge can do almost nothing with Sarah Boone's letters. I know that's bringing in another case, a separate case, but that letter to the judge is an ex parte meeting, and the judge is doing the right thing. He's releasing it to the other side. Hey, she talked to me again. This is what she said. All right. It is also clear that ex parte communications are presumed to have been in error, and once a party has shown that a judge has received an ex parte communication, there is a presumption of harm that can be overcome only by an affirmative showing that the judge did not consider this communication. And case law, where there was a reversal because of this. In the case at bar, there is not a scintilla, I love that word, of evidence to overcome the presumption that these impermissible, illegal, and unethical ex parte communications, as captured in Exhibit B, resulted in harm. Thus, Mr. Williams' case should be reversed on direct appeal if there is any conviction and sentence. Basically, this is a get-out-of-jail-free card for Mr. Williams because it's an instant granted appeal. More case law, where letters sent to a judge by witness were not harmful. Certainly the error did not argue the judge responded in any manner. Okay, so he's talking about the judge responding. That's case law. We're going to skip that part. As shown in the joint affidavit, attached here too as Exhibit A, Judge Glanville not only conducted this improper and unethical ex parte meeting, Judge Glanville therein acted as an advocate for the Fulton County District Attorney's Office as he dispensed legal advice and supported lawyers Hilton and Love's goal to have Mr. Copeland testify against Mr. Williams and the other co-inductees. Also in Exhibit A and Exhibit B. In light of this ex parte proceeding, it is impossible to conclude that Judge Glanville is impartial and not a member of the prosecution team. Judges shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned, including cases in which the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of disputed evidentiary facts concerning the proceedings of Code of Judicial Conduct, Rule 2.11. Judge Glanville has been derelict in his judicial duties and must be recused. They are throwing all the shade on Judge Glanville. Once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon of June 10th, 2024, in open court, lawyers Hilton and Love sat mute while Judge Glanville found undersigned counsel in contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's lawyer, Love's and lawyer Hilton's improper, illegal, and unethical conduct. Now he's bringing the prosecution in, saying they sat mute. They're officers of the court. They knew this was wrong. When the judge was doing something wrong, they said nothing. They just sat there. Judge Glanville must be recused from any further action on Mr. Williams' case. The footnote says, in addition to violations of Georgia rules of professional responsibility, which would carry penalties up to disbarment, felony crimes such as violation of oath of office, as codified in OCGA. He's now not just saying you screwed up judicially, you broke a rule, but now they're saying you have a felony crime on our hands. This needs to be investigated and possibly charged. The reference sections of the Georgia Code of Judicial Conduct are meant to be self-enforcing, and it is the judge's duty to disqualify himself as soon as he's aware of the grounds that exist. More case law for that. Let's see. Lots of case law. In the case at hand, the judge cannot show that Judge Glanville's lawyer or Love's lawyer or lawyer Hilton's intentional... Let's see, let me go back up a little bit. In the case at hand, the state cannot show that Judge Glanville's, lawyer Love's, and or lawyer Hilton's intentional and willful complicity in these ex parte communications was harmless error. As shown in Exhibit B, the improper influence and interjections by Judge Glanville and his two cohorts from the Fulton County District Attorney's Office on Mr. Copeland changed Mr. Copeland's stance to not testify against Mr. Williams. If Mr. Copeland refused to testify, all of his prior false inculpatory statements as to Mr. Williams would not come into evidence based on Mr. Williams' constitutional right to confrontation. Intimidation tactics thrust upon Mr. Copeland by the combined work of Judge Glanville, lawyer Love, and lawyer Hilton resulted in Mr. Copeland's decision to testify, and thus Mr. Williams has another witness to challenge at trial. Footnote says, the law says, an influence of the witness as set forth in the code and the law, as are a few examples of what potentially occurred during this ex parte meeting. Okay, more case law here. Moreover, ex parte communications are so disfavored and repugnant that even if the ex parte communication would be cumulative of all their evidence introduced at trial, same would not be harmless error, because the ex parte communications are presumed to be reversible error, meaning that this is why you grant the appeal. Mr. Williams' fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville, lawyer Love's, and lawyer Hilton's improper, unethical, and ex parte meeting with witness Copeland. Moreover, the cover-up, secrecy, and silence of these three team members, look together, grouping them together, is unforgivable. To wit, after the Star Chamber meeting, the three public officials simply strolled into the courtroom, faced the cameras, called for the jury, and feigned to continue trial as if nothing out of the ordinary just occurred hours or minutes before. And there's the YouTube timestamp to Law and Crime, or Court TV. Mr. Williams needs to examine Judge Glanville, lawyer Hilton, lawyer Love, and when they say examine, they mean call as a witness and question on the stand under oath, and all other members of their prosecution team to reveal the date and time of every ex parte communication that occurred concerning Mr. Williams' case since its inception. the subject of the same, and order of the court reporter to produce any transcript of same and or unseal all documents from these potential improper ex parte communications. They're asking for more. They say, we have one, we want all of them. Undersigned counsel needs to cross-examine all of these parties to ensure that sworn testimony is spread in open court on the record. Mr. Williams' trial is constitutionally broken based upon the unconscionable misconduct of Judge Glanville, Lawyer Love, and Lawyer Hilton, all working together in an effort to convict Mr. Williams. The criminal justice system in Fulton County, in the state of Georgia, and in America has been attacked by the conduct of these three actors. This injustice must end immediately, beginning with Judge Glanville removed and disqualified from Mr. Williams' case. Thereafter, this motion is also timely made for Lawyer Love and Lawyer Hilton to be removed and disqualified from Mr. Williams' trial, and the Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside the actions of Lawyer Love and Lawyer Hilton. Judges must I can't say this word. I wish I could just push a button. You guys could pronounce it for me. Scrupulously avoid improper ex parte communications, whether or not they consider them. A judge has the ethical duty to recuse himself sua sponte, on his own, without emotion, anytime the judge is aware of grounds to do so. Judge Glanville did the opposite of recusing himself sua sponte, even though he is keenly aware that keeping Lawyer Love and Lawyer Hilton to influence Mr. Copeland to change his mind, that helping them change his mind and testify against Mr. Williams is not permitted by any judge in any court. Instead, Judge Glanville, the chief judge of the Superior Court of Fulton County, Georgia, has taken upon himself, at the behest and encouragement of Lawyers Love and Hilton, to ally himself with the prosecutors in this case. Judge Glanville's misconduct shall not stand. The law must be followed. Judge Glanville must be recused and disqualified from Mr. Williams' case instanter. Now. The undersigned counsel objects to any proffer by Judge Glanville, Lawyers Love, and Hilton. Other objections to proffers will be made at the time of the attempted proffer. He says here, we don't want your explanation. I don't want to hear your excuse, Judge Glanville, Lawyer Love, Lawyer Hilton. I don't want to hear you say, oh, but nothing happened. Oh, but it was innocent. We didn't talk about it. I don't want to hear it. Talk to the hand. Talk to the hand, because I'm not here for it. Right? They just need to be recused. No hearing is actually needed to reach the finding that a recusal of Judge Glanville instanter is mandated. We don't even need to talk about it. On the face value of this request, granted, done. I need my gavel for that. Granted. Judge Glanville has automatically caused his recusal and disqualifications for Mr. Williams' case by unlawfully becoming actively involved when he presented argument refuting affiant's allegations of judicial bias. If this honorable court disagrees, Mr. Williams respectfully requests a hearing, as he will call Judge Glanville, Lawyer Love, and Lawyer Hilton as witnesses to fully unmask this above-discussed misconduct, as well as further misconduct that may have occurred. If you disagree, let's have that hearing. But guess what's going to happen? You're going to be a witness, Judge, as are the two prosecutors. We're getting all three of you up on the stand. We're going to ask you all the questions. And guess what, Judge? If you're on the stand as a witness, guess what seat you cannot be occupying? I'll give you a hint. It's the one with the hammer. Yeah, it's going to be under a different judge, and we're going to dig in as far as we need to, they're saying here. This judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County, the Fulton County courts, the Fulton County District Attorney's Office, and stains the court throughout the state of Georgia and our country. They say this stinks so bad, it's everyone can smell the stink you guys have brought into this court system. What occurred in this star chamber, outside the view of the cameras, in the shadows and hidden from Mr. Williams and his counsel and the public, is unpardonable, and all in violation of Mr. Williams' constitutional rights stated herein, as well as in Exhibit A. Judge Glanville, Lawyer Love, and Lawyer Hilton have created secret star chambers proceedings which the state of Georgia has promised its citizens it would never engage. As the Honorable Supreme Court of Georgia has taught, justice faces its greatest threat when courts dispense it secretly. Our system abhors Star Chamber proceedings with good reason. Judge Glanville, Lawyer Love, and Lawyer Hilton have teamed up to conduct their illegal and unethical conduct outside the view of Mr. Williams and his counsel, the public, and outside of the lenses of the cameras. These public officials shall never be trusted by Mr. Williams or undersigned counsel. There are serious consequences for these intentional and unjustified misdeeds that have not yet been dispensed. The clear evidence is that Judge Glanville is not impartial, and or there is at least the appearance that Judge Glanville is not impartial. Judge Glanville must be removed and disqualified instanter from Mr. Williams' case. As sworn to in Exhibit A, Judge Glanville, Lawyer Love, and Lawyer Hilton conspired to conceal and suppress Brady v. Maryland evidence. So this is Brady evidence. This is stuff that has to be revealed to the opposing counsel through discovery. This Star Chamber cannot prohibit Brady evidence from coming forward. That is exactly what Judge Glanville, Lawyer Love, and Lawyer Hilton planned to do. Mr. Williams' constitutional right to due process and fair tribunal and a fair trial, effective assistance of counsel, right to cross-examine, right to see, hear, and be present for statements of a sworn witness have been obliterated by Judge Glanville and his cohorts. Judge Glanville must be removed as he has forfeited his position as judge. You're not fit to wear the robe is basically what he's saying. In June 10th, 2024, Star Chamber meeting between Judge Glanville and his lawyers Love and Hilton. The June 10th meeting with those three undermined the public's faith in the integrity of the justice system as it conceals from the public, Mr. Williams, his lawyers, and the others facing the removal of their liberty, critical information about the lawfulness and reality of how they are being prosecuted. This injustice must end today. This trial is wholly broken and cannot ever be repaired based solely upon the improper conduct of Judge Glanville, Lawyer Love, and Lawyer Hilton. He's hinting at something here. He's hinting at the fix is not just to remove the judge and get a new one. He's hinting at dismissing this with prejudice. That his client, and I think by extension all the other clients in this particular case, not ever face justice if they did conduct the things they're charged with. Let's see if he actually goes that far. Any motion for mistrial made by Mr. Williams is based exclusively upon the improper actions of the supposed judge and the state actors. Judge Glanville, at the indecorous Star Chamber, I've never said that word in my life. Indecorous or indecorous? I don't know what it means. Hey, Siri, define indecorous.
Intercourse means...
Oh, whoa. Siri. That wasn't what I said. That was not what I said. We're going to try that one more time. I think I pronounced it wrong.
Scratch all that. Oh, that was terrible. I apologize.
I was today years old when I... Okay. Hey, Siri, define indecorous.
May be upon us.
Okay. I had to keep the volume down. I'm going to read this. Indecorous is not in keeping with good taste and propriety. Improper. Siri, that's what you were, honestly. You went there. That was not me. That's not on me, guys. I'm not owning that one. Judge Glanville at the indecorous, I think is how it was, Star Chamber ex parte meeting provided legal advice and direction to Attorney Bumpus about how to speak with her client, Mr. Copeland. Dispensing legal advice creates a clear appearance of partiality, which is a proper ground for the granting of this motion to recuse under our Code of Judicial Conduct, and a constitutional violation of due process. More case law. Mr. Williams' constitutional right to due process has been violated because not only is there an appearance of partiality, but there's an actual bias, as Judge Glanville has been embroiled in this trial and is assisting the prosecution to attempt to gain a conviction of Mr. Williams. It is impossible for any reasonable person to believe that Judge Glanville is neutral. I just know that TYO Toys has already clipped that. It's going to show up. Oh, man. You can't trust Siri, of all people. You can't trust Siri. Judge Glanville must be removed based upon the one ex parte communication that has come to light thus far. Judge Glanville, lawyers Love and Hilton have infected the process of Mr. Williams' trial and have illegally poisoned the same forever. There's another hint at that dismissal with prejudice. Judge Glanville had the ethical duty to recuse himself sua sponte once he had these ex parte communications. However, neither Judge Glanville, lawyer Love, nor lawyer Hilton uttered a word that they spent the morning of June 10th leaning on Mr. Copeland to testify for the prosecution against Mr. Williams, coaching attorney Bumpus on what and how to sell to Mr. Copeland the proposition to cause him to testify against Mr. Williams, coaching Mr. Copeland on how to deliver his testimony, and promising Mr. Copeland that he would not be prosecuted even for perjured testimony unless he told, quote, a bold-faced whopper lie. These public officials heard, and public officials is in air quotes. These public officials heard and failed to reveal that Mr. Copeland confessed to committing every indicated offense in this case. Even non-lawyers can see that Judge Glanville, lawyer Love, and lawyer Hilton are not acting in an ethical manner, are on the same prosecutorial team, and that Judge Glanville should not be rewarded with the opportunity to continue to preside as judge over Mr. Williams' jury trial. In reality, Judge Glanville, lawyer Love, and lawyer Hilton have made themselves witnesses whom Mr. Williams' counsel will call. These three lawyers must be recused and removed from the case. It is important to note that Judge Glanville originally denied Mr. Williams' request for access to the June 10th ex parte hearing transcript, keeping the contents of the record totally hidden by lawyer Love, lawyer Hilton, and Judge Glanville. Fortunately, mounting pressure related to Judge Glanville's gross misconduct, violation of his oath of office, ethical violations, and potential criminal conduct by lawyer Love, lawyer Hilton, and Judge Glanville worked to effect change. On Monday, June 17th, 2024, Judge Glanville denied undersigned counsel's motion to recuse and went forward with the trial of this case. Similarly, Judge Glanville denied the Honorable Douglas Weinstein Esquire's motion to recuse on June 12th, 2024. Judge Glanville then continued to unlawfully preside over Mr. Williams' jury trial. Judge Glanville must be removed as he has proven to have actual bias as well as the appearance of bias. Footnote, Mr. Williams' counsel has announced in open court that he will call these three offenders at trial. Judge Glanville's, lawyer Love's, and lawyer Hilton's names appear on Mr. Williams' filed 8th amended list of witnesses. I can never trust Steri to do anything for me again. You guys are still laughing about it in chat. I was mortified. She went there, and that was not what I can replay it, but that's not what I said. Undersigned's counsel has never been afforded the questions that lawyer Hilton and or lawyer Love created and gave to Mr. Copeland. Undersigned counsel was never been given this list of questions, even though Judge Glanville has been made aware of these questions and has encouraged Attorney Bumpus and Mr. Copeland to review and understand these questions. Exhibit B is going to have that. The question must be asked why Judge Glanville has ex parte access to lawyer Hilton and or lawyer Love's questions for a witness. This conduct is beyond repair. Judge Glanville, lawyer Hilton, and lawyer Love did not give a hint that they were meeting ex parte with witness Copeland on the morning of Monday, June 10th, 2024, or at any time. Undersigned counsel had no idea that Judge Glanville, lawyer Love, and lawyer Hilton would dodge the law and ethical rules to conduct this improper and unethical ex parte conference. Thank you, Lenova. Sneak peek. Appreciate the super sticker. We'll go back and get them. I know I've missed a couple comments. We'll get them here when we get a break. But we're about 5% through. Judge Glanville and lawyers Love and Hilton were duty-bound to immediately announce to Mr. Williams, his counsel, and all accused and their counsel that, 1, this ex parte meeting occurred, 2, Brady and Giglio evidence was obtained, and 3, that the transcript was made and allowed argument to flow. Instead, so they should have said there was a transcript, and then they should have had a discussion about it. Instead, their cover-up equals their misdeeds. And we have case law and video evidence as well. Thank you for the super stickers. Guys, I did not intend for that to go that way. This is a family show. Let's see, Ashley, this is 233 pages, and a lot of it is repeat. A lot of them are very quick. There are some pages we'll be skipping. It's not that much reading. It will be done before tonight's Canton Select Board meeting at 7. Judge Glanville lawyers Love and Hilton, acting in concert, hid Brady evidence and attempted to normalize this unconstitutional Star Chamber meeting, unethical conduct, and witness intimidation by deflecting the focus of how undersigned counsel learned of the secret proceeding. Judge Glanville held undersigned counsel in contempt of court. This misconduct by Judge Glanville, lawyer Love, and lawyer Hilton undermines trust in judges and prosecutors, cannot stand, and cannot be rewarded. Action must occur in order to attempt to remove this dark cloud over Mr. Williams' trial and the criminal justice system at large. The conduct of lawyer Love, lawyer Hilton, and Judge Glanville can never be forgotten, normalized, or ratified. The Georgia courts have always safeguarded and separated prosecutors and their duties from judges and their duties. Here, there is no daylight between Judge Glanville and lawyer Hilton's and Love's improper and unethical conduct. All must be removed from Mr. Williams' case, instanter. They're saying, look, have you ever been to a kid's dance, like a youth dance, where, you know, the chaperones are there, and they're like, look, if you can't pass a small paperback book between your bodies when you're slow dancing, you're probably too close, kids. You're too young for this style of dancing. He's saying, Judge, you are slow dancing with the prosecution, and there ain't no daylight visible. You close. You too close. You're way, way, way too close. As stated herein, Mr. Williams intends to call Judge Glanville as a witness at trial, as well as at this recusal motions evidentiary hearing. Okay, so he's going to call him to both this trial that Mr. Williams is defending himself in. He wants to call the judge as a witness. That requires a recusal. And yes, some of you got that reference. And he also wants to call them at the recusal motions evidentiary hearing with another judge, based on upon his improper conduct and the need to make a further record to protect Mr. Williams' constitutional rights. Specifically, there appear to be communications not captured on the transcript of June 10th ex parte meeting. Lawyers Love and Hilton and Judge Glanville's examinations are needed to complete this record. What is telling him there is incomplete discussion? Could it be that the time that he met with the prosecutors outside of Mr. Williams' presence, when Mr. Williams and Mr. Bumpus were together, but the others stepped away? Was that not recorded? Yeah, that wasn't recorded. It was off the record, but it was still an ex parte meeting. Okay, so the voicemail was going off in my room here. Judge Glanville is a necessary witness in Mr. Williams' trial, and his name will be used when the undersigned counsel cross-examines Mr. Copeland when asking questions. Whether Judge Glanville pressured Mr. Copeland to testify, whether Mr. Copeland realized that Judge Glanville was allowing wrong propositions of law to be explained to him, and the fact that Judge Glanville's condoned Mr. Copeland lying under oath unless it was a bold-faced whopper. This mandates that Judge Glanville not be in the courtroom in front of Mr. Williams' jury ever again as judge. Judges must be disqualified in proceedings in which their impartiality may be reasonably questioned, including, but not limited to, instances where the judge is likely to be a material witness in the proceedings. Grounds for recusal are contained in OCGA 1518, as well as the Georgia Code of Judicial Conduct. Further, the judge should be disqualified for bias against a party if such bias stems from extrajudicial.
Burger King. People do not get to have it their way.
There's the Whopper, bold-faced Whopper. It should be disqualified for bias against a party if such bias stems from extrajudicial source and results in an opinion on the merits on some basis other than what judge learned from his participation in the case. The alleged bias of the judge must be of such a nature and intensity to prevent Mr. Williams from obtaining a trial uninfluenced by the judge's bias. In the case at bar, it is impossible to honestly find that Judge Glanville is an impartial, fair jurist. Recusal is mandated. Under Rule 2.11 of the Code of Judicial Conduct, a judge must avoid a judge must avoid all impropriety as well as the appearance of impropriety. Judges shall disqualify themselves in proceedings in which their impartiality might be reasonably questioned. The fact that Judge Glanville's impartiality might reasonably be questioned is grounds to mandate that he is removed from the case. That's it. If it's reasonably, if just it being questioned is enough to remove him, that's how much they need this impartiality to exist. Rule 2.11 provides an additional rule of disqualification that is broader than our statute. Here, under any definition and any rule, Judge Glanville must be removed instanter from the position of judge. In fact, Commentary 2 to Rule 2.11 explains that judges are subject to disqualification whenever their impartiality might be reasonably questioned. Judges should disclose on the record information that the court believes the parties or their lawyers might consider relevant to the question of disqualification, even if the judge believes there is no legal basis for disqualification. That did not happen. That he was caught. He was not open and forthcoming about this. We only have 2 more bottles of water in the house, so here we go. Impartiality might be reasonably questioned means a reasonable perception of lack of impartiality. Whoa, earthquake. I didn't know you could even do that. I've never had that happen before. Apparently, don't twist when you're scrolling. Impartiality might be questioned means that a reasonable perception of lack of impartiality by the judge held by a fair-minded and impartial person based upon objective fact or reasonable inference. Recusal on this ground requires a rational basis for such questioning, not an arbitrary basis, even though no actual impropriety on the part of the judge has been shown. Judge Glanville's impartiality under this definition has been satisfied. Further, the Code of Judicial Conduct mandates that the judge step down from presiding over a case where the judge is likely to be a real and essential witness and where there is not substantially the same testimony available from another witness. Judge Glanville must leave Mr. Williams' case, except when he is called to testify as a witness to explain under questioning his misconduct and bias before the jury. Ivy Berlin says, I feel like a kid at dinner table not understanding a word the adults speak. Can I go to my room, please? I'll try to explain it if I can. Basically, they're rehashing this argument from many different angles. They're basically saying there are 32 different reasons why this judge should be removed. And a lot of them sound very similar, but they're technically a different angle, a different rule, a different violation or alleged violation. And mostly I'm just proud, Ivy Berlin, that I fixed the super chats so you can read words like this, even with a white background. And I did it today. I didn't know I could do that. Pauline Anna says, just to say thanks. Thank you for the super chat. Appreciate that. Let's continue here. We have much more. If this was the stack of documents that we're reading, we've read this much. See? There you go. The basis of Judge Glanville, the bias of Judge Glanville is of such a nature and intensity to prevent Mr. Williams from obtaining a trial free from Judge Glanville's bias and prejudgment. Prejudice, bias, or prejudgment, or even an exhibition of partisan feeling is present in Mr. Williams' case, and Judge Glanville must be removed instanter. Thal says, don't worry, I clipped it and put it on my channel on X and Facebook. I helped. Beams with pride. Thanks, Thal. Yeah, that's going to live on forever. Mr. Williams asked this as honorable court to hold an evidentiary hearing on this motion to recuse the motion to recuse in order for Mr. Williams to gain a full understanding of the misconduct of Lawyer Love, Lawyer Hilton, and Judge Glanville's thought throughout this case. Judge Glanville is so involved in this controversy that his objectivity can reasonably be questioned, and he must be removed as the judge over Mr. Williams' jury trial. The facts are so clear that Judge Glanville, in order to shield himself and his co-prosecutors, Love and Hilton, from the truth of their misconduct, denied Mr. Williams' June 17th motion to recuse without a hearing. He denied it without a hearing, just on the face of the document, without providing a transcript and without permitting another court to hear the motion to recuse dated June 17th. This demonstrates that Judge Glanville is involved in this controversy and cannot be deemed fair and impartial. He should have at least allowed argument on that denial, I think. the rules of disqualification pursuant. Actually, no, he shouldn't have. I think he was right not to allow argument. He was wrong to deny it. It should have gone straight to another judge. He should have looked at it and said, yes, you've got enough there that another judge needs to look at this. Significantly, Judge Glanville is required to avoid not just impropriety, but the appearance of impropriety in his activities. This is because public confidence and respect for the judiciary and our courts must be maintained. As shown in Exhibit A, attached here too, the shocking conduct of Lawyer Love, Hilton, and Judge Glanville provides that bias and prejudice have been shown, and it would be error for Judge Glanville to continue Mr. Williams' case. It has been held to be elementary that a judge must be disqualified when he is going to be a witness in the same proceeding. You can't be the judge and the witness at the same time. Who's going to rule on the objections? In the case sub judice, that's a legal term that I've not seen used before. I think it means in the case at hand. Judge Glanville has taken on the prosecutorial role against Mr. Williams and hence must be recused. These circumstances illustrate perfectly the inescapable conclusion that Judge Glanville is partial to the prosecution and biased against Mr. Williams. Judge Glanville attempted to cover up his and Lawyer Love's and Lawyer Hilton's misconduct by attempting to intimidate undersigned counsel and then holding undersigned counsel in contempt of court, sentencing undersigned counsel to the maximum number of days to serve in custody for doing nothing but zealously and ethically upholding his professional responsibilities. Judge Glanville then took action before the jury after recusal motions were timely filed by Honorable Douglas Weinstein, Esquire, as well as undersigned counsel. All of these actions taken by Judge Glanville after these ripe and valid recusal motions were filed are void. Judge Glanville has caused Mr. Williams immeasurable suffering and prejudice based upon his Lawyer Love's, and Lawyer Hilton's denial of Mr. Williams' statutory and constitutional rights stated herein. Mr. Williams must be granted a reasonable bond. Mr. Williams' statutory right to speedy trial has been totally upended by Lawyer Love, Lawyer Hilton, and Judge Glanville, and Mr. Williams must be cleared of all baseless charges. So this is the first time he's really spelled out, other than getting the judge removed from the case and the two prosecutors removed from the case. It's the first time he's spelled out what he wants to have happen, what a remedy would be. And this, they're saying, we would like Mr. Williams to have a reasonable bond. Right now, if he does have a bond, I'm not sure if he does, it's probably way too high for Mr. Williams to reach. That's why he's in custody. Mr. Williams and the other defendants have been in custody and have been for quite some time, I think 2 years. So he's saying, because of this, we need a reasonable bond, which would get Mr. Williams at least out of jail. Well, it still gets him, it doesn't get him off the hook entirely. But he does mention this cleared of baseless charges, possibly meaning that we need to pare down the actions against Mr. Williams. And it might take it out of the world of the RICO environment. As spelled out above, the supplement to motion to recuse is timely filed as the same is filed not later than 5 days after the undersigned counsel affiant first learned of these additional grounds for disqualification. To wit, on Monday, July 1st, 2024, when the ex parte transcript was first revealed to undersigned counsel. The attached joint affidavit, memorialized as Exhibit A, supports this recusal motion by giving fair support to the charge that Judge Glanville's bent of mind may prevent or impede impartiality as required for Judge Glanville to preside over this case. So the mindset of the judge is so set against the defendant that he cannot preside over this case. Judge Glanville's extrajudicial misconduct cannot be ignored. Judge Glanville, Lawyer Love, and Lawyer Hilton have worked in lockstep. What mental image comes to mind when you think of lockstep? I probably shouldn't even ask that, but yeah, I think he went there, and I think that's an intentional use of those terms. To ensure that Mr. Williams' constitutional and statutory rights to a fair trial, impartial tribunal, due process, right to be present at all critical stages of this trial under the federal Constitution, as well as Article 1, Section 1, Paragraph 7 of the Georgia Constitution, right to cross-examine, right to present a defense, right to effective... Is that 12? Is it 12 or 7? My Roman numerals is not on par today. right to a presumptive defense, right to effective assistance of counsel, right to assist his counsel have all been crushed. This trial is a farce. It's 12. Thank you very much. I caught it myself before you said that. I thought V was 5 and X is 10. This trial is a farce. Denying this motion to recuse and permitting Judge Glanville to continue as judge perpetuates injustice. This case can never return to constitutional normalcy based solely upon the improper misconduct of Lawyer Love, Lawyer Hilton, and Judge Glanville. Any tragic conviction and sentence in this case will likely be reversed. Judge Glanville has made himself a necessary witness as a lawyer, as has Lawyer Love and Lawyer Hilton. Should Judge Glanville not recuse, Mr. Williams would be prevented from exercising his constitutional right to call witnesses, as Mr. Williams needs to show the jury how and why Lawyer Love, Lawyer Hilton, and Judge Glanville were not just doing their jobs, but were teaming up with the unified front to convict Mr. Williams. Once armed with this evidence, the jurors can then properly determine what, if any, there's a what, if any, of this testimony these facts will bear upon their verdicts. Judge Glanville must be removed. Thal says, whatever you do, don't ask Siri what it means. I won't. I'll be very careful from now on. Oh, let's do it. Let's do it. Why not? Hey, Siri, define farce. Siri's not talking to me anymore. Oh, I muted
including
Siri.
crude character.
I muted her on accident. She's still talking. Okay. Let's try this again. Hey, Siri, define farce.
Farce means a comic dramatic work using buffoonery and horseplay, and typically including crude characterization and ludicrously improbable situations.
Yeah, I think he meant to use that word. I think he meant to use that. Mr. Williams' motion to recuse. I knew what it meant, but that rest in peace, channel. Mr. Williams' motion to recuse, an affidavit timely filed on Monday, June 17th, required Judge Glanville to answer a legal question as to whether the motion to recuse meets the threshold requirements. This argument is the strongest argument in my mind, okay? Because the law in Georgia spells out exactly what needs to happen. There is it should be a reflex. I think that's the most like an automatic reflex. When the doctor hits your knee with the hammer and your leg jumps up in the air, I don't know why they do that other than they're like, haha, made you kick. But we're not talking about that. That sort of automatic reflex, this is what should happen. When this motion to recuse is filed, the judge, it doesn't matter where his feelings are on this. It doesn't matter if he thinks it's fair, if he thinks it's not. It should be his reflex should have been to follow these steps, and that is to answer one legal question first as to whether the motion to recuse meets the threshold requirements under the law. This is simply a question of the law. Judge Glanville, acting way outside of the parameters of a fair and impartial jurist, denied Mr. Williams' motion, finding it did not meet the simple threshold requirements. I think he did that incorrectly. That was the first big mistake after he had the meeting and didn't say anything about it. Mr. Williams' June 17th motion to recuse and the attached affidavit clearly met the threshold requirements. This June 18th ruling clearly shows the bias of Judge Glanville. On Monday, July 1st, Judge Glanville allowed undersigned counsel's June 17th motion to recuse to be forwarded to another court. While this shows there is at least a reasonable appearance of impropriety by Judge Glanville, judges shall disqualify themselves from any proceeding in which their impartiality might reasonably be questioned. Judges shall perform judicial duties without bias or prejudice and shall not, there we go, earthquake again, shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice. Judges shall be faithful to the law and maintain professional confidence in it. Judge Glanville has violated all of these critical and worthy principles. Judge Glanville had the duty to act at all times in a manner that promotes public confidence in the impartiality of the judiciary. As seen in Exhibit A, Judge Glanville has abrogated this duty. A hearing must be held to properly document the misconduct between Lawyer Love, Lawyer Hilton, and Judge Glanville. A full evidentiary hearing must be conducted where Lawyer Love, Lawyer Hilton, and Judge Glanville, we need to call them the LHG. We're just going to refer to LHG. Does that work? Because Love, Hilton, Glanville. It's like a gang. Will be called by the undersigned counsel as witnesses to determine the nature and scope of their relationship and misconduct. They say, cite some case law. A full evidentiary hearing was held on the motion to recuse. Before the jury, Judge Glanville will be spoken about in terms of his work as a member of the prosecution team. This meaning the jury is going to be present in court, right? They're going to be sitting there listening, and Judge Glanville will be spoken about by the lawyers as if he is a member of the prosecution, because that's how he acted according to this filing. The law mandates that Judge Glanville will be called as a witness by Mr. Williams. The jury will get to see him, get sworn in, and answer questions. The judge mandates that Judge Glanville be removed from presiding over Mr. Williams' case because he cannot be both a witness and a judge in our lawful criminal justice system. Judge Glanville has given Lawyer Love, Lawyer Hilton, and Honorable Attorney Bumpus and Witness Copeland legal advice. Mr. Williams' jurors need to understand who has been orchestrating this kangaroo court. Whoa. These are strong words. These are very, very strong words. Judge Glanville, Lawyer Hilton, and Lawyer Love, now it's GHL instead of LHG, should have separate and distinct roles in our criminal justice system. This distinction between these roles has been washed away in Mr. Williams' case. When the judge instructs Mr. Williams' jury that by no comment, ruling, or action taken by the trial court should the jury determine that the judge has any bias in favor of a party, when the judge instructs Mr. Williams's jury that by no comment, ruling or action taken by the trial court should the jury determine, is it missing something or am I? Should the jury determine that the judge has any bias in favor of a party? That I lost on that sentence. This will be a disputed point of law. I think he's talking about the jury instructions where the jury's charged at the end of the trial, where the judge says that if you perceive that I had any bias or favor one side or the other, please disregard. I don't. He's saying that this will be a disputed point of law. He said, actually, you do. Mr. Williams will be calling Judge Glanville, Lawyer Hilton, and Lawyer Love as witnesses, and thus this instruction does not apply to Mr. Williams' case. Mr. Williams' jurors must learn the conduct of these three lawyers. Okay, this may be a legal jab. By putting the judge back in the category as lawyer, it's not an insult to call someone a lawyer. Okay? A lawyer is a prestigious position where years of education and intensive schooling and hard work get you to a point where you can take a very hard test, and if you pass the test, you earn the right to practice law. So it's not that calling someone a lawyer is an insult, but calling a judge a lawyer is a little bit of an insult because it knocks him down from where he is. Lawyer to judge is a demotion. Judge to lawyer is a demotion for sure. So there's a lot of shade written between the lines in this thing. These three lawyers, when examining the evidence and evaluating this instruction, Judge Glanville is a necessary witness in Mr. Williams' trial and must be recused. Lawyers Love and Hilton are necessary witnesses in the case and must be disqualified. As attested to in Exhibit A, Judge Glanville received extrajudicial information outside of court and also gave opinions and legal advice that included, but are not limited to, that Mr. Copeland went to prison for crimes committed on behalf of YSL, a contested fact in this trial. Mr. Williams and the other co-indictees know Mr. Copeland and his criminal conduct that is not known to Judge Glanville or the prosecutors. Hang on. Mr. Williams and his other co-inductees, the other defendants, know Mr. Copeland and his criminal conduct that is not known to Judge Glanville or the prosecutors. And Mr. Copeland will be cross-examined on his other crime evidence because Mr. Williams and the co-inductees have far greater knowledge of Mr. Copeland and his background than others, and the like. By embracing this extrajudicial information, Judge Glanville believes that Mr. Williams is involved in criminal activity with Mr. Copeland, and that Judge Glanville expressed that fact to Mr. Copeland in order to push Mr. Copeland to testify against Mr. Williams. These conclusions regarding facts that are in dispute about Mr. Williams' guilt mandate Judge Glanville to be removed from this trial. Yes, everybody onto the bus. The bailiff is the only one he's not saying has to be recused. We might even have a request for a new court reporter, because we clearly have an allegation that there were parts of the conversation that were not recorded. All right. These conclusions regarding the facts are disputed. Mandate Judge Glanville be removed from this trial. Moreover, Judge Glanville's derogatory and prejudicial statements and demeanor must be considered by this honorable court as attached in Exhibit A. Judge Glanville has an ethical duty to disqualify himself in this matter, as he clearly has a personal bias and prejudice concerning Mr. Williams, the other co-inductees, Mr. Williams' counsel, and the other defense lawyers in this case. Judge Glanville has violated his oath by not voluntarily disqualifying himself to avoid this impropriety and appearance of impropriety. Instead, Judge Glanville, Lawyer Love, and Lawyer Hilton have manufactured an unfair, unconstitutional, broken trial and has caused Mr. Williams severe prejudice by incarceration for over 2 years without a bond, and a laughable trial that has lasted entirely too long with the games played by Lawyer Love, Lawyer Hilton, and Judge Glanville. Judge Glanville must be removed instanter. Let me just say that blaming the entire length of this trial on Lawyer Love, Hilton, and Judge Glanville is not quite fair. We have a room full of attorneys, as 6 defendants now, each with 2+ attorneys, have slowed down the process immeasurably. So I think there's, as far as the time frame of how long court's taking, there's plenty of blame to go around. Instanter is a word that means, it's a legal term for now, instantly, this very moment. The instances discussed herein, as well as in Exhibit A, represent more than mere friction between zealous counsel and a diligent jurist. The diligent jurist at this point, they're talking about the judge. And we have seen that in other cases where there is friction between the lawyers and the judge. And that's okay. That can exist. And so he's saying what's going on here is more than that, just that normal friction. Judge Glanville's conduct created the realistic impression that he has harbored an inclination to be biased against Mr. Williams and partial towards Lawyer Love and Lawyer Hilton in the Fulton County District Attorney's Office. Although proven, this honorable court need not decide whether such a bias or impartiality actually existed, because Judge Glanville was ethically bound to disqualify himself whenever his impartiality might be reasonably questioned, including instances where the Judge Glanville's behavior could indicate that he has personal bias or prejudice against a party or party's lawyer. So now, well, it is the prosecution's prerogative to prosecute one at a time or all at once, so they technically did hold up the case. Yeah, but I'm just saying the fact that this case has dragged on for so long is not entirely their fault. I mean, RICO cases are a thing. Thank you, Thal. Judge Glanville's impartiality is more than questionable and is an error to permit him to continue on Mr. Williams' trial. As shown herein and in the attached affidavit, Judge Glanville is disqualified from any contact with this case moving forward based upon his bias against Mr. Williams and or his counsel, which stems in part from extrajudicial sources and results in an opinion on the merits of some basis other than what Judge Glanville learned in his lawful participation of the case. So this is saying the judge is biased against my client and me and the other clients, the other defendants and their lawyers, because of information that he learned outside of court, outside of this courtroom in front of the jury. Okay, it's one thing for the judge to reach a conclusion after hearing evidence and think, I know if I was a juror, I know how I'd vote. That's one thing. But if you instead have meetings outside of court and get outside information and thus make your opinion based on that's what he's saying, that this judicial sources is incorrect, and that's why he says he needs to be removed for that. As cited above, ex parte communications are presumptively harmful error. The state has a burden of rebutting the presumption of harmful error, which it will not be able to do. He says because it's harmful. There is actually harm there. Thus, any conviction and sentence will likely be reversed. There's a check mod chat for an amended motion filed today. Small correction to footnote about the money. Okay, when we get to that, maybe if you could just type because I don't want to re-download. I will lose my place. 233 pages. But when we get to the money part, we'll get to that. There's a slight correction in this document. Let's see. The state has the burden of rebutting, which they'll not be able to do. Thus, any conviction and sentence will likely be reversed. Meaning, it's pointless to move forward on this trial because of what the state has done. Because even if you do convict of my client on every single charge, it will be reversed because of what you've done. Moreover, the issue surrounding the improper, secret, and coercive pressure campaign by Judge Glanville, Lawyer Love, and Lawyer Hilton will become evidence before the jury. In order to attempt to explain this injustice to the trier of fact, that's the jury, Judge Glanville, Lawyer Love, and Lawyer Hilton will become witnesses. Mr. Williams is entitled to know these communications between Judge Glanville, Lawyer Love, and Lawyer Hilton, and or Mr. Copeland. Judge Glanville, Lawyer Hilton, and Lawyer Love have stolen forever Mr. Williams' opportunity to have this trial heard by a jury in a constitutional and statutory firm manner. Judge Glanville, Lawyer Hilton, and Lawyer Love have goaded Mr. Williams into moving for mistrials. All of the conduct and all of the proceedings after the Honorable Douglas Weinstein Esquire, as well as undersigned counsel, filed their motions to recuse and affidavits, are deemed invalid and have no effect. Mr. Williams' constitutional and statutory right to a speedy trial has been stomped on by Judge Glanville, as well as Mr. Williams' right to due process and a fair tribunal, and the other constitutional rights stated herein and the attached affidavit. This conduct must end, and all three of these lawyers must be disqualified from this case. This is interesting, that the statement goaded into mistrial. We might need to ask, to phone a friend and get a lawyer's take on this. Why would the state want the defendant, Mr. Williams, to move for a mistrial? Does that get rid of all the baggage and start again, but still keep the defendant in jail and just resets the clock? Because there's an earlier point in the same document where he said all of the defendant's motions for mistrial have been relating just to this judge's action. So interesting. We'll need to phone a friend to get a legal take on that. I'm not going to ask Siri. The attached affidavit clearly sets forth the facts and reasons for the belief that prejudice and bias exist. These allegations are definite and specific as to time, place, and details as to this extrajudicial conduct or statements which demonstrate both bias in favor of Lawyer Love and Lawyer Hilton and their position on behalf of District Attorney's Office of Fulton County and prejudice toward Mr. Williams and his counsel. Saying we have receipts. The exhibit has all the receipts with timestamps. We've got it all in here. Moreover, there has been a systematic pattern of prejudicial conduct toward Mr. Williams and his counsel and the other co-inductees. I want to say inductees, but it's indictees, and their counsel by Judge Glanville. Lawyer Love and Lawyer Hilton acting together unethically, which has influenced the trial process and has broken the foundation of a fair trial. These are not bare conclusions or opinions, as Judge Glanville attempted to claim after Mr. Williams timely filed his motion to recuse on June 17th. Instead, Judge Glanville was using his position of power and trust to obstruct justice as he has violated his oath of office while Lawyer Hilton and Love sat mute as they violated their oath of office and their ethical responsibilities to ensure a constitutionally fair trial. Lawyer Love, Hilton, and Judge Glanville must be disqualified from further action. Mr. Williams must be released from custody, instanter, and cleared of all charges based upon prosecutorial and misconduct, judicial misconduct. Okay, he went there. He finally went there. Before he said remove, he's ramping up his statement. Before he said he needs to be cleared of some of these baseless charges, saying basically some of these things against my client are just garbage and they need to be getting rid of. But now we have for the first time in this motion that Mr. Williams needs to be cleared of all charges. That means case dismissed. Okay, this is not we need a reasonable bond. This is case dismissed. So he's going for everything now. As explained above, ex parte communications are presumed to be error, and once Mr. Williams has shown that Judge Glanville received ex parte communications, there is a presumption of harm that can only be overcome by affirmatively showing that Judge Glanville did not consider these communications. In this case, Judge Glanville has harmed to its core Mr. Williams' constitutional and statutory rights asserted herein. Judge Glanville, Lawyer Love, and Lawyer Hilton are now self-made witnesses and must be removed from this case instanter. Their conduct is reprehensible. Judge Glanville has never affirmatively stated that he has not considered these ex parte communications. Lawyer Hilton and Lawyer Love have never uttered a syllable denouncing these ex parte communications. Instead, they promote the propriety of these ex parte communications. See Exhibit C. The state cannot refute this presumption of harm, as Mr. Williams' constitutional right to cross-examination, fundamental right to be present to see and hear all goings-on in the court, and pursuant to the United States Constitution, as well as Article 1, Section 1, Paragraph 12 of the Georgia Constitution, his right to due process, right to fair tribunal, right to a fair trial, right to effective assistance of counsel, right to be present at right to present a defense, and right to call witnesses have all been smashed by the unlawful and unethical conduct of these three supposed, air quotes, public officials. Judge Glanville, Lawyer Hilton, and Lawyer Loves have a lot of explaining to do and must be removed from this case, except as a witness. Tiffany Zebrack, mistrial by prosecutorial misconduct applies double jeopardy, I believe. So that's what he's getting at. Double jeopardy applies. You can't try him again because the first trial ended because of prosecutorial misconduct. You can't just try again with somebody who's going to do it right. So wow, thank you, Tiffany, for that clarification. And just for the record, I was able to click on that off screen with my mouse while I was still reading. That was I was pretty proud of that. If you can't tell, that's skill. All right, we're not done yet. We're about a tenth of the way through. I hate to break it to you. We've got time. Buckle up, guys. If you need to get some popcorn, run to the restroom, I'll give you a break. That's all right. But we're not going to stop. So just turn the volume up, or maybe take your phone with you. That's what I do. Judge Glanville had the duty to disqualify himself and recuse himself based upon his misconduct, and had a duty to inform all of the misconduct of Lawyer Love and Lawyer Hilton. The judge had to. This is the first time he's mentioned this. The judge had a duty to inform the defendants of the misconduct by Lawyer Love and Lawyer Hilton. Instead, Judge Glanville, a lawyer Hilton, and Lawyer Love all proceeded like their conduct was normal, proper, and somehow privileged, meaning secret and allowed to be kept quiet. Judge Glanville must be recused. The law also requires this honorable court to recuse. The public must believe in the absolute integrity and partiality of the judges. That is why, even without a showing of actual bias, prejudice, or unfairness, and regardless of the merits and timeliness of any motion to recuse, it is inappropriate for any judge to preside in any action where one of the parties holds a judicial office in any other court which sits in the same circuit. Okay, we're going to hash that over one more time. Without showing bias, actual bias, prejudice, or unfairness, regardless of the merits and timeliness of any motion to recuse. Okay, so this is without there being a problem with bias, prejudice, unfairness, timeliness of a motion. Without all of that, set that aside. It is inappropriate for any judge to preside in any action where one of the parties holds a judicial office in any other court which sits in the same circuit. I think, where are they going with this? So, the judge to preside. So they need a judge from outside the circuit? I think they're asking for a completely unbiased and unconnected judge to look at this. The Supreme Court of Georgia observed that our Judicial Qualifications Commission has opined that a judge in a particular court should never preside over a matter concerning another judge from the same circuit. Okay, there it is. They want to be outside of the circuit. They don't want the judge's friend, to review this. I mean, thank you, Mathis. It means that no judge in the circuit can preside over this case. Thank you for that. The Honorable Court of Appeals has explained that, as said above, the Commission concludes that it would be inappropriate for this Honorable Court to preside in this action where Judge Glanville holds a judicial office, because he is the chief judge in this honorable court, same circuit. Okay, this makes sense now. Therefore, under the law, this honorable court must recuse from this case, because refusing to do so would permit questioning of this honorable court, something the court will not countenance. This court must recuse as well. An appearance of impropriety exists in situations in which reasonable minds might perceive that this honorable court's ability to carry out its responsibilities with impartiality and integrity or competence is impaired. Furthermore, this honorable court has received $2,000. Okay, so this might be amended. Oh no, this is right. This honorable court has received $2,000 donation to its re-election campaign from Judge Glanville in April. So this motion right here is talking to the judge who is hearing the recusal motion. Okay? They're saying you need to step down because you're hearing a case where the person who is a party in the case is an officer in your circuit of the court. Okay? So you're hearing a case where your boss is on trial, right? Not legitimate boss, but that's probably a good analogy, that your boss is on trial, or somebody that you work with, a coworker, and the coworker has a position of power in your field where you work. It's not right for you to hear that case. It should be outside. Somebody that's not connected should be hearing this. Plus, we've got these campaign donations, $2,000 donation from Judge Glanville to the person who's now hearing this recusal motion. Judge Glanville giving this contribution for a re-election could be deemed as an exceptionally large campaign contribution, and thus is another reason this honorable court must recuse from presiding over this case. Case law. Judge Glanville's donation to this honorable court's re-election campaign 3 months ago, coupled with the above-cited case law and Judicial Qualifications Commission Opinion 220, mandate that this honorable court must recuse from this case as it meets in private with Judge Glanville and other Fulton County judges to conduct the business of the Fulton County bench. There is an appearance of impropriety by ruling on this motion to recuse. Wherefore, based upon the above and joint affidavit, as well as the timely filed June 17th motion to recuse and attached joint affidavit, Judge Glanville must be recused. This honorable court must also be recused. We want 2 judges out. We want Judge Glanville out, they're saying, and we want this second judge who is hearing this motion to recuse. You can't do it either. This has to go outside the circuit. And that's signed by by Attorney Brian Steele, who was the man of steel, once held in contempt, took off his suit coat, took off his tie, took off his shoes, and presented his wrist to the bailiff, saying, "Lock me up. I'll go to jail for this, but I'm doing this. This is right for my client, and I'm ethical. I stand by what I've done." It was an amazing moment to watch. Now we're to Exhibit A. Exhibit A is the joint affidavit of Brian Steele and Keith Adams, Esquire. These, I believe, are the two defending attorneys that represent Jeffrey Williams. We are over the age of 18 and suffer no legal disability. We make this joint affidavit based upon our personal knowledge. We are counsel for Jeffrey Williams in the above-styled case. The joint affidavit is timely filed on July 8th, which is 5 days from July 1st, to wit. I know it seems like the math doesn't add up there. Yes, I pronounced it wrong. I still don't know how to pronounce it. I'm hesitant to ask Siri. I don't want to go there again. The 5 days. Why is July 8th 5 days from July 1st? Because math doesn't math there. That's because it's business days and holidays are not counted. So Saturday, Sunday, and holidays are not counted. So we have July 1st is when they heard about it. So we've got July 2nd, 3rd. Now we've got the 4th. That's a holiday. July 5th, that was a Friday. July 6th and 7th are out on July 7th. So we're within that 5 day time frame. That's where we are. All right. The affiants first received the transcript of the ex parte communications that occurred in the chambers of Judge Glanville, dated June 10th. Hence, this joint affidavit is timely filed. That's important because motions have to be timely. Almost all motions have to be timely. Most of them have a period of time in which it's proper for a motion to be heard of this nature. This one is proper, they're saying. Affiants hereby expressly adopt and embrace all the statements made in the motion to disqualify or recuse Judge Glanville and the joint affidavit attached thereto, dated June 17th. Herein, and rely on that timely filed and asserted motion to recuse, as well as the affidavit in tutu. herein. I've never seen tutu. Is that a typo or is that another legal term? Dare we ask Siri? Hey Siri, what is tutu?
Tutu is a dress worn as a costume in a classical ballet performance, often with attached bodice. Shall I continue?
Not along those lines. Hey Siri, what is toto?
Okay, I found this on the web for not along those lines. Hey Siri, what is Toto? Check it out.
She's like, it's the dog. It's the dog in Wizard of Oz. It means it's an adverb, totally or entirely. That's from Merriam-Webster, bailed me out. So basically all the documents attached herein. That makes sense. Siri once again failed us. Judge Glanville met with lawyer Love, the Honorable Attorney Bumpus, lawyer Hilton, and at times the court reporter, sworn witness Mr. Kenneth Copeland, members of the District Attorney's Office including, but not limited to, Fulton County District Attorney's Office investigators Long and Hamilton, as well as members of the Fulton County Sheriff's Department outside of Mr. Williams and his counsel's presence, and discussed critical parts of Mr. Williams' case in violation of Mr. Williams' constitutional rights to a fair tribunal, right to be present, right to due process, a right to a fair trial, a right to assist counsel, and right to confront witnesses. See United States Constitution Amendments 1, 5, 6, 14, as well as Georgia Constitutional Article 1, Section 1, paragraphs 1, 12, and 14. How did I do on Roman numerals that time? Am I okay? The purpose of this ex parte meeting between lawyer Love and lawyer Hilton and Judge Glanville was to act in unison in order to influence sworn witness Mr. Copeland to testify against Mr. Williams. Mr. Copeland, just for the background, he pled the fifth. He got on the stand and pled the fifth. We found out that he did not want an immunity deal. That was not what he wanted. He wanted to get up there and plead the fifth the whole time, and he told the prosecutors he was going to do that. So night before he goes to testify, the prosecutors present him with a gift. Guess what? We've got you this letter of immunity. You can't be charged for anything you say on the stand. And because of that, you can't plead the fifth. You're welcome. Mr. Copeland did not want that. Did not want that at all. And so he pled the fifth. Well, when you plead the fifth, when you have an immunity deal, guess what? You go to jail because you can't do that. And so he was caught in this trap. Let's see. So this meeting was to convince him to testify and not try to plead the fifth on the stand. There was absolutely no lawful purpose for this ex parte meeting to occur, to wit. There was no allegation by Mr. Copeland that he was somehow threatened. There was no allegation by Mr. Copeland that he was not satisfied with counsel. There was no allegation by Mr. Copeland that he needed to meet with Judge Glanville. See, the affidavit also moves to recuse Honorable Fulton County Superior Court Judge Krause, hearing the recusal motion as stated herein. Okay, that's the second judge who was hearing the recusal motion. Instead, this ex parte meeting was orchestrated by lawyer Love, lawyer Hilton, and Judge Glanville to convince Mr. Copeland to testify against Mr. Williams. See Exhibit B. This influence in a witness meeting eviscerated any appearance of regularity in the tribunal and demonstrates, at the very least, that Judge Glanville is biased for the prosecution and against Mr. Williams and his counsel. So being biased for the prosecution and against Mr. Williams means that anytime an issue comes up in court, the judge is going to lean in favor of the prosecution and lean against, dare we? Lean against the defendant. Hey Siri, define eviscerated.
Eviscerate is a formal term. It means disembowel a person or animal.
That escalated quickly. This influencing a witness meeting disemboweled any appearance of regularity. Wow. Lawyer Love begins with this unethical ex parte conference by explaining that the state's reasons for Judge Glanville to meet with sworn witness Mr. Copeland is to impress upon Mr. Copeland that he needs to testify for the same reasons lawyer Love announced in open court on Friday, June 7th, to wit, the Honorable Jonathan Melnick, Esquire, abandoned his client. The lawyer abandoned his client because of that. And then we have the YouTube page link for that. At this point, rather than acting as a true judge, protecting our court system and its reputation by questioning, why am I meeting with an ex parte and why am I being used to answer in front of only members of the state of Georgia questions of Mr. Copeland, Judge Glanville, because he is biased, agreed to help convince Mr. Copeland to testify adverse to the liberty of Mr. Williams. Lawyer Love made untruthful statements about email correspondence with the Honorable Jonathan Melnick, Esquire. Attached here too, emails with the Honorable Jonathan Melnick, Esquire, the Honorable Maxwell Shart, Esquire, and affiant Brian Steele. We get email receipts. We're going to read those in detail. They're going to be great. Lawyer Love continues to make false representations, and Judge Glanville knows if he has paid attention at all during the proceedings. Oh my goodness. If the judge has paid attention at all during the proceedings, that Lawyer Love makes intentional misstatements of fact routinely. Yet, Lawyer Love deflects her misconduct and cites the ethical rules of conduct for attorneys during this ex parte hearing. Lawyer Love explains the need for the ex parte communication. All that aside, we would like an opportunity for the court to address Mr. Copeland with Mr. Copeland's stand-in counsel present to allow Attorney Bumpus an opportunity to explain to Mr. Copeland everything that Lawyer Love has just said. Specifically, those are the lines. Again, Judge Glanville has thrown away all appearance of propriety by permitting this ex parte meeting to occur at the behest of Lawyer Love and or Lawyer Hilton. Judge Glanville is not independent and is being led by the nose by members of the Fulton County District Attorney's Office. This is because Judge Glanville is a member of the prosecution team. Led by the nose? Do you know what's led by the nose? An ox with a ring in it. You tie a string to the... You can literally lead an ox with a string because guess what? It hurts to pull the nose. Okay? It turns the head. Judge is being led by the nose, he says, because he's a member of the team. Judge Glanville then adopts the wrong law offered by Lawyer Love that Mr. Copeland will be held in custody until he testifies. Lawyer Love seems to assert that Mr. Copeland can be kept in custody even after Mr. Copeland's jury is discharged. Judges are presumed to know, respect, and comply with the law. Objectively, Judge Glanville permits several misstatements of law in order to have Mr. Copeland testify against Mr. Williams in order to assist the prosecution. Judge Glanville becomes an advocate for Mr. Copeland to testify against Mr. Williams by telling Attorney Bumpus how to communicate with her client, Mr. Copeland. Specifically, that Mr. Copeland is, quote, going to face some pretty significant cross-examination. And Judge Glanville explains to Attorney Bumpus that it's all in the message and the packaging in terms of how I think Mr. Copeland is, a savvy person. But, he's certainly going to be subject to a thorough and sifting cross-examination. The fact that Judge Glanville is dispensing legal advice and strategies to Attorney Bumpus, guiding her on how to speak with Mr. Copeland in order to have her client testify against Mr. Williams, is a clear, direct fact that Judge Glanville has forfeited his judicial role. Turn in the robe. In the Judicial Qualifications Commission's formal advisory opinion number 241, Supra, former Canon 5F, now Rule 3.10, states that full-time judges shall not practice law. See also former Canon 3B9, now Rule 2.10a. Judge Glanville is biased against Mr. Williams and is partial to the prosecution of Mr. Williams. Judge Glanville, along with Lawyer Love, continues to advise Attorney Bumpus what to tell her client. For instance, part of Mr. Copeland's challenge, Attorney Bumpus, may be that you need to ensure Mr. Copeland, look, I'm going to be here, and if you think that they're asking you a question, they being the state or the defense is asking you a question that's going to bring out other crimes that you're going to, Mr. Copeland's going to be able to look at you and say, I can have a chance to talk with you, Lawyer Love, who is working in lockstep with Judge Glanville, states, and then Lawyer Love, who's working in lockstep with Judge Glanville, states, that's exactly right. Lawyer Love then inaccurately bashes Attorney Melnick by saying, there's been an assertion that people are representing Mr. Copeland's interest. The biggest concern is Mr. Copeland's best interest, and then they're just not here. There is absolutely no reason that Judge Glanville and Lawyer Love are discussing what Attorney Bumpus should be telling her client, and no reason for Judge Glanville to permit Lawyer Love to ridicule Attorney Melnick. Lawyer Love again misrepresents by claiming that the Honorable Attorney Melnick has been talking to Brian Steele and Max Shart. That's it. he's not talking to us. So Lawyer Love misrepresents by claiming that the Honorable Attorney Melnick, quote, has been talking to Brian Steele and Max Shart. That's it. He's not talking to us. Why does Judge Glanville hold this ex parte conference and permit Lawyer Love to falsely accuse affiant and the Honorable Attorney Maxwell Shart of obstruction? That name is so unfortunate. I'm not going to ask Siri to... No. The obstruction of ethical violations by influencing a lawyer-client relationship. This is extrajudicial information that Judge Glanville should never have received. Judge Glanville continued to be a prosecutor for Mr. Williams when he instructs Attorney Bumpus that sworn witness Copeland can invoke the Fifth Amendment if he testifies about unrelated crime. See these lines. We'll get to that in a minute. Judge Glanville tells Attorney Bumpus that sworn witness Mr. Copeland is, quote, probably thinking about, there's lots of stuff the defense could ask me about, and that is not known to a lot of people. Mr. Copeland could also invoke the Fifth Amendment if it was some other particular crime, unquote. During this advice on what to explain to Mr. Copeland, Lawyer Love and Judge Glanville are speaking with one voice. One voice. This is Judge Glanville presuming and pontificating that Mr. Copeland is involved in a lot of unrelated crimes that Mr. Williams, a criminal himself, is aware of the same. Thereafter, Judge Glanville and Lawyer Love jointly explained to Attorney Bumpus that Attorney Melnick injected himself into these proceedings. The fact that Judge Glanville is having these conversations in the first place, then agreeing with and championing the prosecution's cause, mandates, even to a casual observer, that Judge Glanville is biased against Mr. Williams and favors the prosecution. This great bias cannot be more clear when Judge Glanville explains to Attorney Bumpus that she needs to give sworn witness Copeland the questions that the state is going to ask him when he testifies, and to ask Mr. Copeland to tell Attorney Bumpus any other facts that they, meaning Mr. Williams and his co-inductees, might ask about. Further, as long as Attorney Bumpus has knowledge of other crimes that sworn witness Copeland has committed, Judge Glanville states that Mr. Copeland will be fine because the state is only going to get in the questions that was provided to Mr. Copeland. It is ridiculous to claim that Judge Glanville is not biased and is impartial. Judge Glanville continues explaining to Attorney Bumpus that the reason she needs to know from Mr. Copeland what crimes he has committed in the past is, quote, the defendants know more about Kenneth Copeland than anyone else, so they are probably going to kind of, unquote. What gives the Judge Glanville the right to state that Mr. Williams knows more about Mr. Copeland's supposed bad conduct than anyone else? In reality, Mr. Williams hardly knows Mr. Copeland. Judge Glanville has pronounced guilt onto Mr. Williams. Judge Glanville imparts legal direction to Attorney Bumpus on how to prepare Mr. Copeland for cross-examination and how to prepare Attorney Bumpus to object on behalf of Mr. Copeland. Judge Glanville has tarnished this trial forever, as Mr. Williams could never have a fair trial with the way Judge Glanville has acted, both in front of the jury and outside of everyone's presence in ex parte meetings with Fulton County District Attorneys and witnesses. The conduct of Judge Glanville, Lawyer Love, and Lawyer Hilton has caused them to be necessary witnesses at trial. The affiant intends to call as witnesses and cross-examine Judge Glanville, Lawyer Hilton, and Lawyer Love on how many other ex parte meetings the three of them and any other member of the prosecution team have had. Judge Glanville cannot be judge and witness in the same proceeding. Lawyer Love and Judge Glanville, acting in concert, that's how we sing in the morning. When we sing Happy Birthday, we act in concert, tell Attorney Bumpus that Mr. Copeland can cancel legal representation because Lawyer Love, Lawyer Hilton, and Judge Glanville have done everything to clear Mr. Copeland of judicial exposure. Without any reason to believe that Mr. Copeland might be fearful for his personal safety, Judge Glanville injects this safety concern as a hypothetical reason that Mr. Copeland would not testify. Lawyer Love, misrepresenting emails, continues the theme of Mr. Copeland's personal safety. There is no evidence of same. Judge Glanville tells Attorney Bumpus that Mr. Copeland has to give testimony, though, that's what he has to do. Mr. Copeland's got to give the testimony, whatever it is, good, bad, or indifferent. The question must be asked, why does Mr. Copeland have to give testimony? Is it because it favors the prosecution? Whose vantage point does Judge Glanville view this trial, good, bad, or indifferent? To whose position? Judge Glanville must be recused. The court reporter announced, off the record, Mr. Williams intends to call at trial Lawyer Love and Judge Glanville to determine what was discussed during this off-the-record time period. So the court reporter announced off the record. That was the announcement. We are off the record. Mr. Williams intends to call at trial Lawyer Love, Judge Glanville, and to determine what was discussed during the off-the-record time period. If we're off the record, it doesn't mean that people can't talk, right? We've seen Judge Boyd. When she talks to witnesses, she's like, okay, we're off the record, and then she continues, right? And she talks. That just means there's no record of it. It doesn't mean things didn't happen. And just because there's no record doesn't mean it didn't occur. They say, on the record, when we have Judge on the stand, in the witness box, we're going to ask about what else happened. What happened off the record? Judge Glanville has the audacity. Do you want that word? Hey Siri, define audacity.
Audacity means a willingness to take bold risks. Do you want to hear the remaining one?
Yes.
It means rude or disrespectful behavior, impudence.
Judge Glanville has the audacity to bring sworn witness Copeland into his chambers without the request of Attorney Bumpus, but at the same, without the request of Attorney Bumpus, but at the request of Lawyer Love. From 9:34 a.m. until 10:03 a.m., nothing is recorded by the court reporter. Affiant will call Lawyer Love, Lawyer Hilton, and Judge Glanville to probe what occurred during this time period. Once in custody, represented by counsel, sworn witness Mr. Copeland is brought involuntarily into the Judge Glanville's chambers. Judge Glanville explains, quote, I just wanted to bring you over and let you talk with Attorney Bumpus and see if there's anything that you need to ask of your counsel or Miss Hilton or the state, or the court, in bold, before we bring you out this morning, because we would like to hear your testimony. And it is kind of where we are at this point in time. It is hard to articulate, that's unquote. It is hard to articulate how wrong this ex parte summit is and how obvious it is that Judge Glanville discarded the sanctity of the judiciary to become part of the prosecution team. Judge Glanville is biased and on this case is constitutionally broken because of the conduct of Lawyer Love, Lawyer Hilton, and another member of their team, you heard it, Judge Glanville. Why is Judge Glanville inviting Mr. Copeland, a represented party, to ask questions of Lawyer Hilton or other members of the district attorney's office of Fulton County or the court? This is beyond comprehension for an impartial, seasoned jurist to act. This is because Judge Glanville is not acting as an impartial, seasoned jurist, but is part of the prosecution team and must be recused. Lawyer Hilton makes it clear that Mr. Copeland has never stated that he has a safety concern, which is stopping him from testifying. Hence, this whole safety concern discussed earlier was totally fabricated by Judge Glanville and Lawyer Love. Mr. Copeland states, I have never been truthful a day in my life until I just made this statement right now. Mic drop. This is quintessential Brady evidence. Judge Glanville never uttered a word, nor did Lawyer Hilton or any member of the Fulton County District Attorney's Office provide the defense notice as to this Brady evidence. This had to be turned over. Same is unconscionable. Affiant intends to call Judge Glanville as a witness at trial, as well as Lawyer Hilton, to discuss the failure to reveal this information to Affiant, and for the jurors to be able to understand. The jury has a right to know that when a judge reads the instruction that the court has no interest in this case except for a fair trial, same is not truthful, as Judge Glanville is on the prosecution team. Judge Glanville, Lawyer Hilton, and Lawyer Love will be called as witnesses and have been added to Mr. Williams' witness list as announced by Affiant in open court. The fact that these three persons attempted to hide Brady evidence is beyond the pale. Judge Glanville instructed the jury that he has no interest in the case except to see a fair trial. Same is untruthful, as the jurors need to hear from these three witnesses in order to make the determination on whether same was truthful or not. Lawyer Hilton gives inaccurate legal information on whether Mr. Copeland can be prosecuted at all and gives some far-fetched ideas about the federal statute of limitations and the state of Georgia statute of limitations. Judge Glanville sits idly by and allows Lawyer Hilton to misrepresent to sworn witness Mr. Copeland that he cannot be prosecuted for crimes. Anyone with a modest interest in this case would know that prosecution has called Mr. Copeland an unindicted co-conspirator and that the supposed RICO conspiracy statute of limitations continues today. Thus, Mr. Copeland could be prosecuted, both in federal court and in the state of Georgia, for crimes. This is wholly contrary to what Lawyer Hilton and Judge Glanville allowed Mr. Copeland to believe. Moreover, Lawyer Hilton and Judge Glanville do not disclose other Brady v. Maryland Supra evidence, as Lawyer Hilton explains that the court can assist Mr. Copeland with finding different places to live. This is part of an agreement that should have been revealed pursuant to Giglio. Same was not done. Lawyer Hilton is a witness at trial and will be cross-examined by affiant on these ongoing misstatements to Mr. Copeland and the failure to reveal Brady and Giglio evidence. Same applies to Judge Glanville. Lawyer Hilton then tells Mr. Copeland, who at the time was a represented person, that he can speak with her without Attorney Bumpus present. Judge Glanville did nothing to stop this potential unethical conduct. Lawyer Hilton again tells Mr. Copeland that he is immunized from prosecution, while Judge Glanville sits silent. The statement is not true, as Mr. Copeland received only use immunity. Order of use immunity, it's going to be in Exhibit F. We're going to talk about that. However, Judge Glanville reinforces Lawyer Hilton's wrong information because Judge Glanville is a part of the prosecution team. Judge Glanville tells Mr. Copeland that he will not be prosecuted for any crime. Judge Glanville and Lawyer Hilton are acting as one, not separate as required by law. Judge Glanville explains to Mr. Copeland that if he is, quote, worried about what the defendants may ask you because they may know your business, you can't be prosecuted for any of those, unquote. First, that is not true, since Mr. Copeland was only given a use immunity as to affiant's knowledge. However, it is clear that Judge Glanville is an assistant to the prosecution because Judge Glanville... Shame on you, sir. That scared the daylights out of me. Judge Glanville, in order to help the prosecution, needs Mr. Copeland to testify and gives Mr. Copeland advice about cross-examination. Importantly, Judge Glanville again asserts that Mr. Williams and other co-inductees may know your business, quote, know your business, but if they ask you things about...
He's the guy.
Turn this down a little bit. Sorry, guys. They ask you things about that you might think you might have some liability with, you can't be prosecuted for any of those, unquote. This presumes that Mr. Williams knows Mr. Copeland's criminal endeavors because Mr. Williams is a co-conspirator with Mr. Copeland. Judge Glanville is far from acting as an impartial judge. Mr. Copeland again puts an end to any made-up safety concerns and explained that he does not want to testify because he will set a bad example for his family based on his past misdeeds. I don't want my kids to know what I did, he says. One must ask why is this ex parte conference occurring and why does it continue? The only logical answer is that Judge Glanville, Lawyer Love, and Lawyer Hilton, acting in concert, had an agenda to ensure that Mr. Copeland testifies against Mr. Williams in order to convict Mr. Williams. This is the definition of a biased judge and unethical prosecutors. This trial is constitutionally broken forever because the outrageous actions of these three, air quotes again, public officials. Lawyer Hilton never provided to affiant the Brady material that Mr. Copeland had told her in the past that he was a liar. Judge Glanville sits mute and does not ask whether this Brady evidence was provided to affiant. Mr. Copeland explained that he has never told Lawyer Hilton that the Honorable Attorney Melnick was not his lawyer, and thus Lawyer Hilton met with a represented party. Lawyer Hilton met with a represented party. Judge Glanville does nothing to discuss this potential ethical misconduct by Lawyer Hilton, Lawyer Love, and other members of the Fulton County District Attorney's Office. This is because Judge Glanville is also a member of the District Attorney's Office of Fulton County. He might as well wear the badge. DA Judge Glanville. Lawyer Hilton told Mr. Copeland that he would be held in custody until, quote, every last defendant has been tried, not just the 6 on trial, the other ones too, unquote. Judge Glanville sits mute and delegates his judicial discretion of punishment to Lawyer Hilton because Mr. Copeland does not have to be housed in custody until, quote, every last defendant has been tried, unquote. Judge Glanville, like Lawyer Hilton, attempts to intimidate Mr. Copeland by telling Mr. Copeland that if he chose not to testify, Mr. Copeland would be held in custody until all 12 co-inductees' cases come to an end. This is just not true. In fact, Judge Glanville is not even the judge on the other co-inductees' cases, as the same is being presided over by the Honorable Judge Dempsey. Again, Judge Glanville and Lawyer Hilton failed to reveal to affiant Copeland's statement that I quote, told the police whatever different story I could think of to try to finesse my way out of the situation, unquote. Instead of turning over Brady evidence, Lawyer Hilton with the support of Judge Glanville, explained to Mr. Copeland that he can simply testify, "I don't recall." Judge Glanville, Lawyer Hilton, and Lawyer Love are inseparable and biased against Mr. Williams. Judge Glanville advocates for the District Attorney's Office of Fulton County when he tells Mr. Copeland to just, quote, "tell the truth," unquote, while Lawyer Hilton is telling Mr. Copeland, quote, "just tell the truth," unquote, and let Lawyer Hilton worry about impeachment, and Copeland will not get in trouble. This excuses Mr. Copeland from giving false statements to the law enforcement officers with a statute of limitations tolling provision. However, Judge Glanville tells Mr. Copeland to not worry about criminal violations, as the commission of same would not get Mr. Copeland into trouble. Do you hear the police? There they go. Seemingly, Judge Glanville, Lawyer Love, and Mr. Copeland spoke, quote, "off the record." As Judge Glanville recounts, quote, "as Miss Love said this morning." Remember, Miss Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on similar charge. I mean, that particular false statement, unquote. Thus, Judge Glanville and Lawyer Love will be called as witnesses and cross-examined by affiant as to what was discussed, quote, "off the record." Judge Glanville is a necessary witness in this case. So they're using this as evidence to say there is stuff that happened that was improper, off the record, not recorded, that we want to know about because you referenced it right here. Remember this morning when Lawyer Love told you this? We don't remember because it wasn't included in the transcript. The transcript is incomplete. Judge Glanville is a necessary witness in this case, as is Lawyer Hilton and Lawyer Love, and hence Judge Glanville must be recused, removed, and disqualified from his high position of judge, in air quotes, as he has voluntarily, knowingly, and intelligently forfeited the same. Judge Glanville also sanctions a lie that is not a bold-faced whopper and is allowing Mr. Copeland then to seemingly lie about something that is not a bold-faced whopper. This is improper. Mr. Copeland states indirectly that if he confesses while testifying to murder, there is no statute of limitations for murder, and he will be prosecuted, and Lawyer Hilton stated that he will not be charged. Judge Glanville sits mute during this exchange. This Brady and Giglio evidence never...
People do not get to have it their way.
There's the whopper again. This evidence never made its way to the affiant by Judge Glanville or Lawyer Hilton or anyone else with the Fulton County District Attorney's Office. This, again, is unforgivable. Moreover, when Mr. Copeland is speaking about murder, Lawyer Hilton states that if she shows Mr. Copeland is lying, to wit, knowingly lying on a material matter under oath in a judicial proceeding, i.e. perjury, Mr. Copeland would not be prosecuted for false statements. Again, this is Brady Giglio evidence that Judge Glanville and Lawyer Hilton failed to reveal. Judge Glanville is no longer acting as a person on the judiciary, but is acting along with Lawyer Hilton and Lawyer Love in an impermissible manner. Mr. Copeland told Lawyer Hilton that she knew Mr. Copeland would plead the Fifth Amendment prior to taking the stand. Lawyer Hilton denied the same. Judge Glanville was silent. This is also Brady evidence and impeachment evidence. This makes Lawyer Hilton and Judge Glanville witnesses. Judge Glanville, the reason why you cannot put a witness on the stand that you know is going to plead the Fifth. You cannot do that, because when a witness pleads the Fifth on the stand, the jury can basically decide that what they would have said had they testified truthfully is bad. They can infer a negative outcome. You can't do that. You can't knowingly put a witness on the stand that pleads the Fifth. Judge Glanville assured Mr. Copeland that he will not get in trouble for testifying, and his testimony would then be impeached. Why would Judge Glanville say this? This could be a false statement. This could be a perjured testimony. Yet Judge Glanville is promising witness Copeland that he would not get in trouble. This is not conduct becoming of a judge of the great state of Georgia. Judge Glanville ruled in his Star Chamber that if the state wanted to impeach Mr. Copeland, the state can do the same, and Mr. Copeland would not get in trouble for that. Why is Judge Glanville explaining and anticipating rulings on what may happen in court? Judge Glanville must be removed and disqualified from the bench of Mr. Williams' trial. Lawyer Hilton then explained that even if Mr. Copeland commits perjury, it would be treated as an inconsistent statement. This, again, is Brady Giglio evidence not revealed to undersigned counsel. Judge Glanville sat silent and seemingly in agreement with Lawyer Hilton. Judge Glanville sat silent as Lawyer Hilton told Mr. Copeland that he has spent some spent enough time in prison for YSL. This is extrajudicial information to Judge Glanville that marks YSL as a criminal street gang, a material element of counts in the indictment, including count 1, RICO. This statement marks that a person supposedly associated with YSL are guilty of criminality. This entire illegal and unethical ex parte conversation was during a critical stage of the proceedings for which Mr. Williams, as well as his counsel, had the constitutional right to be present for, based on the United States Constitution as well as the Georgia Constitution. This Star Chamber meeting also violated Mr. Williams' right to be present, as well as right to counsel, effective assistance of counsel, right to be present, right to present his defense, right to due process, right to a fair trial, right to a fair tribunal, and statutory right to a fair trial and ethical prosecution. All of these rights have been denied based on the improper conduct of Lawyer Love, Lawyer Hilton, and Judge Glanville, all working together on the prosecution team. Lawyer Hilton explained that Mr. Copeland that, quote, "No one here expects Mr. Copeland to remember every single detail from 2015, unquote. Why is Lawyer Hilton able to speak for Judge Glanville, who was present but silent? Is it because they are on one team? Judge Glanville has denied Mr. Williams of a fair trial and violated Mr. Williams' constitutional rights stated above and herein. Lawyer Hilton and Judge Glanville functioned as one cohesive engine, as shown clearly by the following." Mr. Copeland asked, "You can't give me house arrest?" Lawyer Hilton answers, "No. You can go home by taking the stand and testifying. That's what you," Judge Glanville then states, "and come back tomorrow." Judge Glanville allows Lawyer Hilton to be the judge by telling Mr. Copeland that he cannot have time to think about whatever he's going to testify or not testify, and that he cannot be sentenced to house arrest but will remain in jail. This colloquy illustrates one fact, that Lawyer Hilton, Lawyer Love, and Judge Glanville are working together as one. Judge Glanville has forfeited the right to be the judge on Mr. Williams' case as he is biased. In fact, a fair judge does not have to keep a person who refuses to testify in jail. There are other punishments besides the same, including a fine, house arrest, or whatever else the judge deems appropriate. What legal right did Lawyer Hilton have to pronounce punishment upon Mr. Copeland? Judge Glanville fights for the prosecution by stressing to Mr. Copeland, quote, "They want your testimony. That is all they want, whatever it may be." Judge Glanville is an advocate for the state. Why does Judge Glanville tell a witness that the state wants his testimony? That's all they want. Why does Judge Glanville care that the state wants a witness's testimony? That is not the concern of an unbiased judge. Lawyer Hilton explained that Mr. Copeland will not be charged with perjury, although that is outside the order of the use of immunity that was provided to Judge Glanville. No Brady Giglio evidence was provided to Judge Glanville provided by Judge Glanville or Lawyer Hilton. This is legally wrong. Lawyer Hilton and Judge Glanville misstate the law of perjury and give promises of no prosecution. This again is Giglio Brady evidence that was not revealed by Judge Glanville or Lawyer Hilton. And in fact, the same was hidden from Mr. Williams until Mr. Williams insisted on receiving this transcript. Judge Glanville and Lawyer Hilton are necessary witnesses, and Mr. Copeland confessed to them, quote, "I did these crimes, I'm telling you that." Coupled with the earlier statements by Mr. Copeland about murder, which does not have the statute of limitations, Mr. Copeland is telegraphing that he is responsible for the indicted offenses. This critical, exculpatory evidence was not given to affiant by Lawyer Hilton, Lawyer Love, or Judge Glanville. In fact, the same was hidden. Affiant will call Judge Glanville, Lawyer Hilton, and Lawyer Love as witnesses because the jury needs to see and hear how Judge Glanville, Lawyer Hilton, and Lawyer Love cajoled perjured testimony from Mr. Copeland, hid Brady Giglio evidence, and worked together to wrongly convict Mr. Williams. Hey Siri, define cajoled.
Bejeweled means adorned with jewels. Do you want to hear the remaining one?
No, that was bejeweled. Siri, define...
Okay, I found this on the web for no, that was bejeweled Siri.
Hey Siri, define cajoled.
Jeweled means adorned, set with, or made from jewels.
Siri's broken. Hey Siri, define cajoled.
Cajole means persuade someone to do something by sustained coaxing or flattery.
Okay, so maybe I was broken. Thank you, Siri. That's all. You may go now. Cajoled instead of cajoled. You're going to get something about, yeah. Persuade, bribe, or coax. Those are good definitions. All right. The instruction that the judge has no interest in this case is not true. Mr. Williams will invoke his constitutional right to present a defense and call all necessary witnesses, including these 3 cohorts. Judge Glanville must be recused. In a separate motion, Lawyer Hilton and Lawyer Love must be disqualified from continuing on this case for their misconduct. Judge Glanville is a necessary witness also because he handed an unknown document to Mr. Copeland's attorney in Mr. Copeland's presence. Affiant will cross-examine Judge Glanville regarding why he would give this unknown document for Mr. Copeland. The jury needs to hear from Judge Glanville so they can determine whether Mr. Williams has been given a fair trial by a detached, impartial jurist as claimed by Judge Glanville throughout this case. Lawyer Hilton will be called as a necessary witness because she, like Lawyer Love, met with Attorney Bumpus and or Mr. Copeland for an unknown amount of time off the record. Affiant will examine Lawyer Hilton on the promises she made Mr. Copeland and other witnesses in the past as well that are not revealed to Affiant. Judge Glanville and Lawyer Hilton, working together, attempted to have Mr. Copeland dress in civilian clothing to appear before the jury as a witness. Why would Judge Glanville care how State's witness Copeland appears before the jury? This is specifically true since Judge Glanville did not do the same with an earlier witness, specifically Mr. White, who testified in jail clothing. Judge Glanville and Lawyer Hilton speak for each other. Lawyer Hilton answered Mr. Copeland's question on whether he would be locked up for this, and Lawyer Hilton responded in front of Judge Glanville, "So long as you testify, we will get an order to get you released." Judge Glanville remained dutifully silent as Lawyer Hilton explained that we would obtain an order to have Mr. Copeland released. Judge Glanville, Lawyer Hilton, and Lawyer Love are one and inseparable as they violate all the named constitutional rights of Mr. Williams and their respective oaths of office. Again, Judge Glanville and Lawyer Hilton handed Attorney Bumpus documents, who then gave Mr. Copeland unknown documents, and Affiant will again examine Lawyer Hilton and Judge Glanville on the witness stand on the contents of these documents and why they were given and the reason for putting pressure on Mr. Copeland to testify against Mr. Williams. The jury has a right to know whether Judge Glanville has committed numerous ethical and unlawful violations, and Judge Glanville must be recused. These are not the only times that Judge Glanville has shown bias against Mr. Williams and or his counsel. Judge Glanville initially refused to release the transcript of this ex parte hearing and that occurred in his chambers on June 10th because he claimed the same was privileged. Obviously, that statement is ridiculous. It's almost redonkulous. Additionally, Judge Glanville must be recused automatically since he defended his position against Mr. Williams' motion to recuse filed on June 17th. This honorable court, Judge Krause, must also be recused, as she sits on the Fulton County Superior Court bench alongside of Judge Glanville and has accepted election campaign money from Judge Glanville, specifically receiving $2,000 in April. This occurred during Mr. Williams' current trial, which commenced on January 4th and is ongoing. I swear that the above is true and accurate. Signed, Brian Steele. It even notarized. Beautiful. You almost feel the texture on that notary stamp. It looks beautiful. I love the serrations. Or the ridges. It looks cool. I want a notary stamp, but I don't want to be a notary. I think it's a crime. Isn't it a crime to be in possession of a notary stamp if you're not a notary? We are approaching 20% through this. That's 2-0. I wish we could say we're further. Kimbers, Ohio says, I'm a notary. It's a pain. It's a pain. All right, we're not done. Now we have the transcript of the ex parte hearing. This is spice. We have gone over this before. For those that have not heard this, we're going to read probably most of this. It's actually a fairly short transcript, I think, and it's double spaced, so it goes really fast. That's good. 20% in 2 hours. Are we going to be done by the time the Canton? I'm going to need lunch at some point. You don't want AI to read? No, I don't want AI to read. AI can't feel the passion of the argument that's embedded in these statements. I can barely read some of the words, but I think I can do a better job than AI. This is made for puppets. It is. If I could figure out how to work the scroll at the same time, we would do the finger puppets. Angela says, did I miss you were going to broadcast the Canton meeting? Apparently you did. Yes, we're broadcasting the Canton Town Select Board meeting tonight. 7 p.m. tonight Eastern Time is the beginning of the meeting. They have 15 minutes of open public comment. Lunch via IV. Yes, because I can't stop to chew. Yes, we're covering the Canton meeting. This is going to be the first Select Board meeting in Canton, and where the Karen Reed trial was sort of centered around since the mistrial, because there was no meeting on July 4th. All right. Here's the ex parte meeting beginning at 9:10 a.m. Present in the chambers are Judge Glanville, Assistant District Attorney Adrian Love, Attorney Kayla Bumpus, Court Reporter Christina Weaver, and investigators Antonio Long and Rashid Hamilton. Court reporter says, "Okay, I'm ready whenever you are." Miss Love says, "Thank you." This is finger puppet material. We'll give it a try briefly. Oh, look, here is into autofocus. Oh, I want to use this one, but it's green, and so you get like, this is the court reporter because it looks like the court. It's a green outfit. Okay, so who do we have here? Wish we had a judge one. I've got a farmer. Got a fireman. This lady with a stop sign. This is going to be, lady with the stop sign is going to be Miss Love, I think. I'm just resting my voice here. We're going to continue, guys, in just a second. We have a nurse. Nurse is going to be, I don't know. We'll figure out who everybody is. And now I need somebody for the judge. Mailman. Is Mailman going to be the judge? Now, how do I work the mouse? Okay, so we have a couple people. Oh, we'll need the attorney. Here she is. Okay, it's backwards. This is a little complicated. This is harder than it looks, guys. Being a puppet master is takes skill. I'm afraid I'm going to accidentally give you the bird when I try to talk, and I don't want to do that. But oh man, you guys, we're going to get these puppets working at some point. I just can't with this one. It's just too in depth. Oh, Mrs. R.A.'s here to work the puppets. Is that what you want to do? No. I'm starving to death slowly. I'm just going to stand idly by and watch. Can you get me some lunch? Preferably something I can consume by IV would be good. All right, so here's the transcript from the ex parte meeting. The court reporter says, "Okay, I'm ready whenever you are." Miss Love says, "Thank you. The concern was that we wanted to bring to the court's attention, as the state was twofold. Once, we wanted to have the opportunity to impress upon Mr. Copeland, with representation present, that he faces, and we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was sort of, we had to pull him into the courtroom when the jury came out." There we go, refocus. There we go. The second concern that I have is that I wanted to bring to the court's attention, in line with the concern that I expressed on the record on Friday. I don't know what advice counsel may have offered or be offering. That is their right and their business. As it relates to testifying, however, I do not believe that criminal exposure is a concern that is which interest is being spoken about and protected. Mr. Melanik relayed to Ms. Hilton on Friday that he had never heard of the statute 255507, and on Friday he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shart. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele and Mr. Shart with me and Simone copied, where he said, "This is the communication that I received from Ms. Love regarding Mr. Copeland." My response was, "Whose interests are you protecting, yours or Mr. Steele's? Whose clients? Which client are you protecting? Whose client, yours or Mr. Steele's? And Mr. Shart's?" He wrote back and said, "You're going to get him killed. You're making him a target. I need a word. You is what he wrote in the email. So, given that this concern is that by testifying, at least the one that he conveyed to me in writing, his concern has nothing to do with the exposure from the state. And if his concern, the court says, his being whose concern? Ms. Love says, Mr. Melnick's. In the interest that he is protecting Mr. Copeland's freedom, he did not convey it by asking us what the exposure does he face in testifying. In fact, he's concerned that testifying will get Mr. Copeland killed, and he's not communicating with us. He's communicating with the counsel for defendants. It would seem that he knows a thing or something that we don't know. Additionally, and I will let Miss Bumpus tell you, he has said that if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if your interest is your client, then it would seem you would want to be there for him while he is testifying. Judge says, well, he is on vacation this week. Ms. Love says, I understand. That is why he has Miss Bumpus here. And he has said that he has said what he has said. And as I was reading the statute, the thing that is, and I was reading the statute about this particular situation, and I was reading our rules, our ethics rules for conduct for attorneys. Probably for the first time, I think she says. No, not for the first time. It's not in there. Strike that. And it was clear that if an attorney, there were two things that were happening. One, Mr. Melnick, he told me that he wasn't Mr. Copeland's lawyer. Mr. Copeland had told Miss Hilton that Mr. Melnick wasn't representing him. And then rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Shart. And Mr. Melnick reaches out to Mr. Copeland and injects himself in these proceedings. What we were discussing was in no way a matter that Mr. Melnick was representing Mr. Copeland on, and that is where we were not allowed to speak with a person when they are represented by counsel. Mr. Melnick could not have been representing Mr. Copeland on anything we were talking about because we were talking about this case and this trial. All that aside, we would like an opportunity from the court to address Mr. Copeland with Mr. Copeland's stand-in counsel present. Miss Bumpus is looking at me like, Miss Bumpus says, I'm listening. Ms. Love says, with this stand-in counsel present and to allow Miss Bumpus an opportunity to explain to Mr. Copeland everything that I've just said. Her concern outside was what is the longest he can stay in jail. What I relayed to her is that the statute says until he purges. The court says by testifying. Ms. Love says his contempt by testifying. The court judge says, yeah, 507 is a little bit different. So, I mean, Ms. Bumpus says, so until the end of this. Judge says, he can be here until the end of the trial. Ms. Bumpus said, that is what I said, to the end of the trial is the longest. Mrs. Love says, no, it's not the longest. Even after a grand jury, if a person has been subpoenaed to testify before the grand jury, and even after the grand jury has, convened, has left, that person can stay until that person purges himself of contempt by testifying. The statute literally says that. Ms. Bumpus says, well, I'm going to look it up because it was my understanding that it wasn't until the end of the trial. Ms. Love says, nope, here it is. Literally, the words of the statute. And so the judge says, he could be in there a while. Let's put it that way, either way. Ms. Bumpus says, I just want to be able to give him, court says, I know. It's kind of the statute says, that you purge, but I can't keep him there indefinitely. I've got to kind of, Ms. Bumpus says, right, that's all I want to know. Court says, the whole thing is that he has keys to his own freedom. And that freedom is, if he just gives his testimony, then he's purged it. Ms. Bumpus, right. Ms. Love says, and whatever that testimony is, we know what we believe it to be, but, we don't know what it is. We can't talk about it. We don't. We don't know what he's going to say. We have an idea. We know what he's told us. Ms. Bumpus says, yeah. Ms. Love says, and our concern is that I know the court has said essentially you intimated that Mr. Melnick probably told him essentially you should testify. They can't do anything with your testimony. But what we overheard being said was, quote, they're going to hammer you, unquote. As if we're going to expose Kenneth Copeland to... Ms. Bumpus says, you heard that? Ms. Love says, yes. Mr. Melnick told Mr. Copeland we're going to hammer him. The judge says, now to be fair, and I think Mr. Bumpus has an advocate or anybody has got to tell him he's going to face some pretty significant cross-examination. Ms. Bumpus says, yeah, I think that's what he meant. Judge says, he's got about 10, talking about how many other attorneys want to line up to question him. Ms. Love says, so he meant the defense is going to hammer him? Ms. Bumpus says, no, just in general, it's not going to be, hey, da-da-da. I think she's saying that. Who's ringing the bell? Oh, my kids are ringing we have an antique front door that has a twist to ring doorbell. And the kids like ringing it. It still works. Beautiful. It's 115 years old. Let's see. Miss Love says he knew that. He'd already been expressing that. The judge says, but I think that if he's concerned about that, but it's all in the message and the packaging in terms of, I think Mr. Copeland is, a savvy person. But, he's certainly going to be subject to a thorough sifting cross-examination. Ms. Love says, and the other thing is that, Ms. Bumpus cuts in, can I say something in Attorney Melnick's defense in response, just for the record? Ms. Love says, yes. Ms. Bumpus says, the reason that he doesn't want to move forward with representation, what I've been told, if he decides to testify, is that he doesn't feel like he doesn't know what was said outside of his presence. So he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. Ms. Love says, but the thing is, the only thing that he should be concerned about is the criminal exposure or the exposure that Kenneth Copeland has criminally. And there is nothing. There is literally nothing. The state is quite clear that we can do to him about the only thing that would put him in harm's way is a lie and a refusal to testify after being ordered to do so by the court. And by lie, I don't mean like, oh, I think you're lying. It would have to be, something obvious, because we can always impeach. But if he literally perjures himself, that's something different. We can't help that. We can't control that. We would only say, tell the truth. I don't care how bad it is, just tell the truth. So, like he says, I didn't go down to the police station. Judge says, and I think that part of this challenge, Ms. Bumpus, may be that you need to assure him, look, I'm going to be here, and if you think that they're asking you a question, they're being the state or the defense is asking you a question that's going to bring out other crimes, that he's going to be able to talk with you, look at you and say, can I have a chance to talk to you? Ms. Love says, that's exactly right. Ms. Bumpus, Ms. Love says, see, but that's just it. Ms. Bumpus says, no, he's not. Ms. Love says, hold on. That's just it, Judge. The problem is that there's been an assertion that people are representing, and I'm not talking about you. Ms. Bumpus says, yeah. Ms. Love says, there's been an assertion that people are representing that their biggest concern is that his best interest, and then they're just not here. And Ms. Bumpus is saying that she's not in a position to do that. Ms. Bumpus says, no, I'm not saying that I'm not in a position. I'm saying that the agreement between Mr. Copeland and Mr. Melnick, who I'm standing in for, is that if he chooses to testify, I'm going to get him to sign this paper that says that then discharges Melnick as his rep. That's their agreement. I can't do nothing about that. Ms. Love says, that sounds weird. That does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I'm not going to represent you. I don't even know what to do with that. Ms. Bumpus says, well, he said he does know what was said. He said he does not know what was said. Ms. Love says, it doesn't matter what was said. Ms. Bumpus, right. Ms. Love says, it doesn't matter. And he didn't ask us. He didn't even inquire, what have you all talked about? He has been talking to Brian Steele and Max Shart. That's it. And he's not talking to us. And in fact, when Mr. Copeland has to speak to us, Mr. Melnick barges in and gets between Mr. Hilton and Mr. Copeland and literally keeps us from talking to him before he gets called to the stand. And that's troubling. Ms. Bumpus says, well, I think what happened was, I say this because I previously represented Mr. Copeland previously on his other stuff. So I know this is just what I think happened. I think how Attorney Melnick became involved was his representation of because he took my place. Copeland fired me and hired Melnick. And then this came about. And I think so at the beginning, Melnick was representing him. And then Ms. Love says, in this criminal matter that he had, but that's resolved. Ms. Bumpus says, but when this case started, Melnick called me and told me that he was representing him as a witness at the beginning. I can assert that. Ms. Love says, Melnick has never in life. Ms. Bumpus says, this is 2 years ago. Ms. Love, Melnick didn't, as a matter of fact, less than 2 years ago when Copeland was sitting in jail for something else he had done, Melnick said, I don't represent him. He told me, I don't represent him. And people were in the room. He was on the speaker. He told me he didn't represent him. Now he ultimately did come about and represent him. But when we were trying to get, I guess, Ms. Bumpus says something, yeah. Ms. Love says, Copeland was like, he's not my lawyer. I don't have a lawyer. He's not my lawyer. And then Ms. Bumpus says, are you talking about recently? Ms. Love says, so recently Copeland said that Melnick was not his lawyer. Ms. Bumpus says, right. Ms. Love says, when Copeland was in jail, Melnick told me he wasn't his lawyer. But our understanding was that Melnick was his lawyer for those criminal charges. And so the person that came in and argued or at least stood in for him on his bond and then his subsequent plea was Melnick. But I don't know whose interest he would be representing when he's not talking to us about what we've been spoken to Copeland about. He could ask us and we would tell him, so I don't know why he would withdraw his representation of him. If his client, if his interest is Kenneth Copeland, then why would you pull out? The court says, that doesn't make sense. Ms. Love says, at the point where he would face the most peril, if that was his concern. If his concern is, if I don't know what they talked about, so I don't know what, judge says, and I thought that Miss Hilton had a list of questions for Mr. Copeland anyway. Ms. Love says she did. What was that noise? Did somebody do a command? I heard a weird squeak noise in my earphones. I think. Maybe I'm going insane. The court says, well, how come you all can't? Ms. Love says, he didn't ask to see those. He didn't. And not only that, judge says, well, can't you all share that with Ms. Bumpus? Ms. Love says, well, Ms. Hilton has already shared it with Mr. Copeland, and we certainly will share it generally speaking. Ms. Bumpus says, can I read this email that Melnick sent me? I don't know if this will help you understand what he's saying. It says, hey, Kayla, I wasn't able to see Kenneth today. He went on Saturday and tried to talk to him before his flight. But I've talked to his family. So at first, Kenneth was going to testify, but now he's decided to take the 5th. He may change his mind on Monday. If he does, he's agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA's office, so I can't really help him with his testimony. And then he gave me the discharge and told me that if he decides to testify, then he's to sign this. Ms. Love says, and that's just it. It's like you never know what somebody's going to ask, and if he's concerned about putting him in legal jeopardy, then it would seem like he would retain and allow Mr. Copeland access to counsel when Mr. Copeland's concerned that he's about to walk into an area that puts him in legal jeopardy. Ms. Bumpus says, you can't switch how he gets called? Ms. Love says, see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. When you say switch in how he gets called, what does that have to do with anything? Ms. Bumpus says, I don't know. Maybe he's saying he can't do it because he can't get to his refundable ticket. Ms. Love says, that is not what he said in the email to you, and that's not what he relayed to the court, and his concerns have nothing to do with, the judge says, he was very much, Ms. Bumpus says, I tried to go back and watch as much as I could. Court says, telling me what he was, that he was going on vacation, and I said, well, you inserted yourself in this. I said, really, you need to come on Monday. Ms. Love says, so he can't force Mr. Copeland to discharge him just because Mr. Copeland decides to testify. Court says, I think you are until it's done. I mean, Ms. Bumpus says, who? Me? We need a stretch break. We might take a lunch break here in just a minute. I think we've got a little break before we bring Mr. Melnick in for the transcript. Give us a little bit more. A little more water. The court says, yeah, I mean, that's just it. If he testifies, you've got to she has to be his lawyer. Ms. Love says, and frankly, Your Honor, I know that if a person faces criminal contempt, they're entitled to representation if they want it, this being a civil contempt matter. Judge says, not necessarily. Anybody who's facing contempt can get counsel. I mean, not anybody, but Ms. Bumpus says, I can't stay. How long is this going to take? Ms. Love says, might take some days. Ms. Bumpus, Ms. Love says, and see, that's just it. And I think Ms. Bumpus is put in a precarious position. She's not the one that stood up and injected herself into this. They reached out to her, and she did him a favor. But ultimately, it seems that if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings, and that is a problem because that has nothing to do with the best interest of Kenneth Copeland, and that has nothing to do with Kenneth Copeland's exposure if he testifies. Just to answer the question about what he is exposed to statute, the statute is very, very clear. It literally says that no testimony or evidence required under a court's order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning which he testified or produces evidence under the court's order. That is saying, even if he got on the stand and said, judge says, he started talking about an unrelated crime, which is the biggest thing I think he's probably thinking about, is that, yeah, there's a lot of stuff they could ask me about. Ms. Love says, right. Court says, that is not known to a lot of people. He could invoke his Fifth Amendment with the advice of counsel if it was some other particular crime. But Ms. Love says, but even that, judge says, even that, he'd still have to testify. Ms. Love says, literally, right. The law says. Judge says, yeah, I mean, anything he testifies to. Ms. Love says, we do this. Ms. Bumpus, okay. Then about the delay or stall, isn't it true that, or is it not true that he had a leave filed since December? Ms. Love says, we have nothing to do with any of that. He injected himself into this. Court says, yeah, see, the problem is, Ms. Love says, he stepped in. Court says, that when you get involved, I don't know you have leave. Ms. Love says, right. Judge says, and unless you filed that leave into this case, you don't have leave for my case. Ms. Love says, right. Ms. Bumpus, okay. Ms. Love, and he did not. The court says, so he didn't have one. Ms. Love says, Mr. Copeland's been a witness and a name on this witness list since. Judge says, so since he said, well, I represent him, I'm like, okay, well, you don't have the leave that's filed in our case. Ms. Bumpus, okay. Ms. Love says, so did he so he did this to himself, and he did it to you. But we have to, that is just where it is. And I don't know that's just where we are. Ms. Bumpus says, so Judge, you're going to make me stay if he chooses to testify? Court says, I am. Because you're his lawyer. You're his lawyer. You're a stand-in lawyer at this point. Ms. Bumpus says, Your Honor, I don't have a problem with that. I'm not ready. Ms. Love says, Court says, there's nothing for you to be ready about. I mean, here's the thing. I think the only thing you've got to kind of ask him about is, look, here's the questions the state's going to ask you. All right, is there anything else that could hurt you that they might ask you about? As long as you have that knowledge of that, and then I think that you're fine, because the state's only going to get into this, talking about the paper. Now, the reason you want to know what's going to hurt you is the defendants know more about Kenneth Copeland than anybody else. So they're probably going to kind of, Ms. Bumpus says, what if I say I can't do it? Then Melnick needs to come back, right? Am I going to be in trouble? Because I was only for Monday. That's what I was told. I was given specific. Ms. Love says, if Copeland said, and I don't know what Mr. Copeland wants, it's his choice. Ms. Bumpus, can't he say he doesn't want Melnick? Can he? Ms. Love says, he can say whatever he wants. It's his choice. Ms. Bumpus, but the judge is saying, Ms. Love, I don't think he can be forced to have representation if he doesn't need, or say he wants it, because we've done everything to clear him of judicial exposure. He's not. There's nothing he can say. He could lie. That puts him in, the court says, peril. Ms. Love, peril. But, he can't talk about a crime that we could prosecute him for. The court says, that is involving this or some other place. Ms. Love says, right. Ms. Bumpus, I understand that, but Ms. Love says, and we can't use this testimony to go and to find evidence to prosecute him for the stuff he talks about. Basically, he's literally shielded. Ms. Bumpus said, I would have to agree with you that I don't think that's the concern. Isn't that what you said? Ms. Love says, well, but the court said that. Ms. Bumpus, no, I'm saying that with Mr. Copeland not testifying. You said you don't think that his concern is criminal exposure, or do you think that's what he's worried about? Court says, do you think that he's fearful of testifying for other reasons, like for personal safety? Ms. Bumpus, right. Ms. Love says, that is what Mr. Melnick said to me in an email I can pull up. He said, Ms. Bumpus, but don't you believe that? Ms. Love says, quote, you are going to get him killed. That's what he said. We ain't going to kill him. Ms. Bumpus, see, I don't know anything about that email. Ms. Love says, we ain't going to kill him. I can show you the email, but we're not going to kill Kenneth Copeland. Who is he talking about? So what are you trying to do? The court says, this is a collateral second and a third order effect. Let's pray it doesn't happen. But Ms. Love says, so what he's saying here, the judge says, this is collateral damage. We're going to order that he has to talk. And if he gets killed for it on the outside, it happens. That's what he's saying there. Just pray it doesn't happen. Ms. Love says, obviously the court says, first he has to give the testimony though. That's what he has to do. He's got to give the testimony, whatever it is, good, bad, or indifferent. Good, bad, or indifferent, I should say. Ms. Love says, so we would like, with the court's permission, they haven't brought him over, and he was supposed to be the first one up, so I guess they went out to get him. They might be over there with him now. Court says, is he here now? Ms. Love, I don't know. Judge Glanville exits the chambers for a few minutes at 9:33. Ms. Love says, we would like just to go into another courtroom and talk to him, give you a chance to talk to him, and then give you the opportunity to explain to him. Court reporter says, we're off the record. There's a brief recess. Judge Glanville and Mr. Chamberlain entered the chambers at 9:34. Ms. Love says, Ms. Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. Court says, where's Mr. Copeland? Mr. Chamberlain says, they took him upstairs to the tank in 9. Court says, okay, we can bring him out to, can we... Mr. Chamberlain says, your chambers are just being used. Your courtroom is being used. Judge says, let's bring him in here. Mr. Chamberlain says, all right, so let me see if I can get that done. Court says, let's bring him in here. Okay, let's thank you. We'll just bring him in here. So now we're going to stop for a recess. We've been reading for 2.5 hours or thereabouts, and I'm feeling a little lightheaded. I need some lunch. We are about a third of the way through. Amber, what did you get me into? Let's pause just briefly because I can't read straight anymore. We've got a bunch of membership messages I want to I'm going to save this spot. Bring a few things in here. Let's see. We have Tammy from Kansas. Almost a year of wild rides. Woohoo! Thank you. I'm glad you made it, even though my portal to this live stream did not work. Unholy Saint 88, thank you for 14 months of support. Love that. Braxton Heaps, 5 months. Been here since middle of Maya. Member for 5, but been here longer. Thank you, Braxton. Good supporter of the program. Lauren here, member for 6 months. Missed y'all. You're here now, Lauren. Welcome. Greeners says for Amber's re-election campaign. Thank you, Greeners. Patricia Cisco, member for 9 months. Been watching since Brooks' trial, but 9 months. Wow. Time flies, Patricia. Cindy Collins, member for 7 months. A series getting feisty. Series sure did. Lenova sent a super sticker. Thank you very much. Jules04 sent a super sticker. Thank you very much. Let's see. Ivy Berlin. I feel like the kid at dinner table not understanding a word the adults speak. Can I go to my room, please? Can I take my food? Thank you, Ivy. Pauline Anna says, just to say thanks, thank you. And then Thal has a couple here. Says, don't worry, I clipped it and put on my channel on X and Facebook. I helped. Beams with pride. He's talking about Siri giving a definition, which we're not expecting. Thal says, okay, everybody under the bus. You, judge, under the bus. You, prosecution, under the bus. You, bailiff, under the bus. Everybody. Thal, again, now, well, it is the prosecutor's prerogative to prosecute one crime at a time or call all at once. So technically, they did hold up the case. They have. Tiffany Zabranick says, mistrial by prosecutorial, word got me. Mistrial by prosecutorial misconduct applies double jeopardy, I believe. So thank you for all of those. I appreciate your support. I realize I have not been following the questions in chat very well. I don't think we have any volunteers who want to take over. Tammy says, whoa, heard my name. Thanks, Tammy. Thank you. Good to have you here. Remember this, Love now leaves, she doesn't return. When Hilton is there, Judge references something. Love told Copeland that morning, but it's not in the transcript. That's what they're talking about when they're saying there's something missing from the transcript. There was additional information. And because it's not in the transcript, the additional information, the defense has the right to presume that it was bad. They can presume that it was bad. Adam says, I'll read a paragraph. Can you start over? Came in late, says Beth. I cannot, but I need to take a lunch break. Here's what we have going on today. First of all, Alec Baldwin's jury trial is proceeding. I haven't checked to see if they have a jury seated yet. They had 79 people they were going to try to pick a jury from. If those 79 didn't work, they had another 79 ready to bring in. I'm not sure why 79 is the key number. It might be how many people are allowed in the courtroom at once. But they're going to try to seat a jury from that. Once they have seated a jury, they're going to break for the day. So nothing in Alec Baldwin will go on today, then other than possibly a little bit of business because there's some paperwork to wrap up from yesterday. After that, they haven't even started jury selection yet. Whoa. After that, then they break, and then we start with opening statements in trial tomorrow morning. And we'll be picking that up with the Alec Baldwin trial. That's the Rust shooting. Do you guys see this? It says announcement from Echo Dot. This is my kid's playing with the Echo Dot, and that's the voice I heard. I need to know that it messes up my computer. All right. So that being said, we're going to go to lunch. We're going to take a break. We'll come back, continue reading this. The meeting tonight is the Canton Select Board meeting that starts at 7 p.m. We are going to live stream that as it happens. It might be spicy. We've got some public comment period, particularly that we're interested in. So, Welsh Lady says, I'll read on StreamYard with you anytime. We might have to do that. I think we'll do the next segment on StreamYard and see if we can get some guests to read a little bit. All right. First, let me go to lunch. Let me get some food. I'm about to pass out. I've been talking nonstop. Tonight, when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again in about an hour. If we do that, Debbie, an hour for lunch. Does that work? I'm showing it's about 1:30 here, so 2:30. We're not going to get this done in time for the Canton meeting. Okay, we'll figure it out. So an hour for lunch. It'll be a bit before I have the live stream set up, because especially if I switch over to StreamYard, it takes a little bit to set that up. But we'll get it sorted out. All right, you guys, be good to each other. Have some lunch. Check out the counter. We're almost up to 8, 9, 8-9. We'll be at 9 million before you know it. Just another 2 days maybe at 9 million. All right, we don't portal. There's no stream yet to Portal 2. We'll be back after lunch. Just I'll let you guys all have a break. You don't have to watch anything in the meantime unless you want to. Be good to each other. We'll see you after lunch. I'm going to have a salad. Delicious.
I'd agree that everything you just said is one of the most horrible things.